committed sexual act. As a result, she became pregnant. Mugu again ಆಗಿದೆಯಾ ಅಥವಾ still pregnant ತಗ್ಸಿದಾರ ಏನಾಯ್ತು ಮೇಡಮ್? As a result, she become act of petitioner. The victim became pregnant. Hence, it is not a fit case to exercise the discretion in favor of the petitioner when the victim statement as well as the medical evidence goes against the petitioner. In view of the discussions made up, I pass the following order. Bail petition is rejected. 41 Nagaraju HR. ಇಲ್ಲ ತಗೊಳ್ಳಿ, ಪಾಸ್ ಓವರ್. ಬರೋದವರೆಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ, ಬರೋದೇ ಇಲ್ಲ ಕೋರ್ಟ್ಗೆ. 42 ಪ್ರವೀಣ್ ಸಿ, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್, ಅಫೆನ್ಸ್ 392, ಪಾಸ್ ಓವರ್. ಚಂದ್ರಹಾಸ ರೈ, ಮಾಡಿಫಿಕೇಶನ್ ಆಫ್ ಕಂಡೀಷನ್ ಇದ್ದಂಗೆ ಇದೆಯಲ್ರಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್, ಪಾಸ್ ಓವರ್. 44 ಶಿವಸ್ವಾಮಿ, ಯಾವಾಗ್ಲೂ ಬಂದು ವಿಡಿಯೋ ಎತ್ಕೊಂಡು ಕುತ್ಕೊಳ್ಳೋರು ಇವತ್ತು ಇಲ್ವೇ ಇಲ್ವಲ್ರಿ? ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಕ್ವಶನ್ ಕೇಳಿದೆ ಸ್ಟ್ರಾಂಗುಲೇಷನ್ ಬಗ್ಗೆ, ನಾಪತ್ತೆ. ಪಾಸ್ ಓವರ್. 44 ಅಲ್ಲ 45. ಲಾಸ್ಟ್ ಟೈಮ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಅಂತ ಮಾಡಿದೀವಿ. ಪಾಸ್ ಓವರ್. 46 ಚಂದ್ರಕುಮಾರೇಗೌಡ, ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್. 47 ಪಾಸ್ ಓವರ್ ಆದ್ರೆ ರೀಚ್ ಆಗೋದಿಲ್ರಿ, ಮತ್ತೆ ಯಾವಾಗ ಬರೋದು? ಆಯ್ತು, ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ. 48 ಗಿರೀಶ್ ಜೆಟಿ, ಇದು ಏನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಮಾಡಿದ್ವಿ, ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ ಏನ್ ಕೇಸ್ ಏನ್? 363 376 ಆಗಿದೆ. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಹಾಕಿ ಅಲ್ಲ ನೀವು ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಏನು ಆಗಿದೆಯಲ್ರಿ? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ, ಹಾಕಿ ಏನೂ ಹಾಕಿಲ್ಲ, ಬರೀ ಒಂದು FIR ಹಾಕಿದ್ದೀರಿ ಅಷ್ಟೇ. FIR ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ನೋಡಿ. Petitioner counsel submits that charge sheet already been filed and hence seeks time to place the charge sheet material and hence this matter on 21st. ಅಷ್ಟೊಳಗೆ ಹಾಕಿ. ಸುನಿಲ್ ಕುಮಾರ್ BN ಆಲ್ರೆಡಿ ಗ್ರಾಂಟ್ ಆಗಿದೆಯಾ? ಅದಕ್ಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಬ್ಸೆಂಟ್, ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿ ಆಬ್ಸೆಂಟ್ ಇದ್ರು ಅವರು. ತೊಗೊಳ್ಳಿ. HCGP submits that already trial court granted bail and hence the petition become infructuous. 50 ಅರವಿಂದ್ ರೆಡ್ಡಿ, ಹೇಳ್ರಿ. 363 376 4 and 6. 4 and 6 ವಿಕ್ಟಿಮ್ ಏಜ್ ಏನ್ರಿ? 14 years. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ? Where is the report? 45 42 40. Given reason given by victim, story history given by victim. Remand not intact. Medical evidence can neither confirm nor refute that sexual intercourse has had occurred. 164 statement ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಲ್ಲ ಅವಳು? ಇದೆಯಾ? ಓದಿ. ಬಟ್ ಏನು ಹೇಳಿಲ್ಲ, ಏನು ಹೇಳಿಲ್ಲ. ತೊಳಿ heard the petition of counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that This petition, ಇವನೇನಾ accused number 3 na ಇವನೇನಾ accused ಒಬ್ಬನೇ ಅಲ್ಲ. This petitioner was working in Akshara. When the CW who used to visit the medical store, he used to talk to CW2 and he was telling around that he is loving her and took CW2 along with CW1 and 3 to different places. And in a vacant flat in an apartment, subjected her for sexual act 4 to 5 times. And hence, the case has been registered and investigated the matter and filed the charge sheet. The counsel appearing for the petitioner would submit that though an allegation is made that this petitioner subjected her for sexual act 4 to 5 times, there is no any material. And victim girl also not stated anything before the learned magistrate. Fact that this petitioner fell in love with the CW2 is borne out from the records of the prosecution case. And when there is no any material to invoke section 4 and 6 of the POCSO Act, keeping this petitioner in custody amounts to curtailing the liberty of this petitioner, and hence he may be enlarged on bail. For counter, the counsel appealing for the state would submit that it has emerged during the evidence investigation that she was subjected to sexual act and the victim girl is aged about 14 years and the hymen is not intact, and hence there is a prima facie case. Having heard the respective counsel and also on perusal of material and record, it discloses that both of them fell in love and no doubt the hymen was ruptured. The victim girl, who has been examined before the learned magistrate, not stated anything about this petitioner subjecting her for sexual act. And apart from that, medical evidence also not clear. And opinion of the doctor is that can neither confirm nor refute that sexual intercourse has had occurred. And medical opinion is also not clear. And when suspecting the factual aspects and when the victim also not stated anything before the learned magistrate that this petitioner subject for sexual act, and in the absence of prima facie material, it is a fit case to exercise the discretion under section 439 of CRPC, enlarged with conditions. Next, Naveen Kumar. Naveen Kumar.
I'm representing petition counsel, please. I'm representing petition counsel, please, madam. Says serial number 51, please.
Yes, counsel.
Lordship, kindly, the petition is the accused number 1 and husband of the complainant, please, madam. The offense is under section 506, 488, 376 and read with 34, please, madam.
376?
506, 488, 376 and read with 34, please, madam.
Why an allegation against husband invoking section 376?
I would like to take your lordship kind attention to page number 53.
Charge sheet already filed. Counsel, go to column number 17 of the charge sheet.
Idರಲ್ಲಿ connected matter ನಿನ್ನೆ bail ಕೊಟ್ಟಿದ್ದೀರಿ ಸರ್ accused number 2 ಗೆ. The main allegations against accused number 2, please, my lord.
A2. 376 A2 ಯಾವುದು ಅದು ಆಯುರ್ವೇದಿಕ್ ಡಾಕ್ಟರಾ?
ಹೌದು, please, my lord.
ನೀವೇ ಕರ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ರಿ ಅಂತ ಗಂಡನು ಅತ್ತೆನು ಸೇರ್ಕೊಂಡು ಕರ್ಕೊಂಡು ಬಂದ್ ಬಿಟ್ರಿ ಆಯುರ್ವೇದಿಕ್ ಡಾಕ್ಟರ್ ಅಂತ, ಹೌದಾ?
I would like to take your lordship
ಕರೆಕ್ಟ್ ಆಗೋದು ಓನ್ಲಿ A2 ಮಾತ್ರ. ತೊಗೊಳ್ಳಿ
53 ಇದೆ ಸರ್, ಪೇಜ್ 53 164.
ಸ್ವಲ್ಪ ಒಂದು 5 ನಿಮಿಷ ವೇಟ್ ಮಾಡಿದ್ರೆ ಆರ್ಡರ್ಸ್ ಬರ್ತದೆ, ವೇಟ್ ಮಾಡಿ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that this petitioner is an accused, and allegation against this petitioner that both of them were not having any issues, and brought to the accused number 2 to treat his wife, and also an allegation against this petitioner and also the accused number 3 that they are encouraging the accused number 2 for sexual act. And also subjected the victim for both mental and physical cruelty, and also abused and caused life threat, and also subjected for dowry harassment. And police have investigated the matter and filed the charge sheet. The counsel appearing for the petitioner would submit that this court already granted bail in favor of accused number 2, who has been charged for the offence under section 376 of IPC. And only allegation against this petitioner with 6 of IPC and also section 3 and 4 of Dowry Prohibition Act. And investigation has already been completed and no need to continue them in custody. Further, the counsel appearing for the state would submit that this petitioner along with accused number 3 only encouraged accused number 2 to commit the offence under section 376, and also subjected the victim for both mental and physical cruelty as well as subjected for dowry harassment, and hence not entitled for bail. Having heard the petitioner, counsel and also appearing for the state and also looking into the factual aspects of the case, the marriage was taken place on 27/3/2018, and earlier there was no any issues to this petitioner and also the complainant, and subsequently the accused number 2 help was taken in treating the victim, and in this connection an allegation is made invoking section 376 against accused number 2, and offence against accused number 2 attacks 376, and this court already granted bail in favor of accused number 2 in criminal petition number nenne ಮಾಡಿದೀವಿ ನೋಡ್ಕೊಬಿಡಿ ಮೇಡಮ್. ನಂಬರ್ ಇದೆಯಂದ್ರೆ
7066 of 21
7066 of 21 nenne date ನೋಡ್ಬಿಡಿ, ಅದನ್ನ ಚೆಕ್ ಮಾಡಿ. And also having taken note of the gravity of the offence and allegations made against these petitioners, and also with regard to the allegation of cruelty as well as dowry harassment, and the same is a matter of trial. In view of discussions made by pass the following order. Bail petition is allowed with conditions. Next 52 Devarajapi. Last time we ilva Devarajapi. Last time no representation. 53 Manjunatha K. ಹೇಳಿ counsel ಹೇಳಿ.
The letter took place between the father and son. Son is the petitioner before his armed court mega. In the course of quarrel, petitioner is alleged to have stabbed his father, his father. Consequently, he died mega. Thereupon, mother of the petitioner not a complaint mega.
Mother of the petitioner. ತಾಯಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು ಸಾಯಿಸಿದ ಅಪ್ಪನ್ನ. ಏನಿದೆ ಡಾಕ್ಟರ್ PM ರಿಪೋರ್ಟ್ ಏನಿದೆ? ಐ ವಿಟ್ನೆಸಸ್ ಇದಾರಾ? ಐ ವಿಟ್ನೆಸಸ್ ಇದಾರೇನ್ರಿ? ಇದಾರೆ ನೋಡಿ ಐ ವಿಟ್ನೆಸಸ್. CW complainant as well as other eyewitnesses are also CW 4 5.
But the same complainant
I3 eyewitnesses ಇದಾರೆ, ಜೊತೆಗೆ ಸ್ಟಾಬ್ ಇಂಜುರಿ ಆನ್ ಅಕೌಂಟ್ ಆಫ್ ಸ್ಟಾಬ್ ಇಂಜುರಿ ಓನ್ಲಿ he died. ಹೌದಲ್ಲ? ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಏನಾರ ಆಗ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ. ಅದು A2 ಗೆ ಬೇಲ್ ಕೊಟ್ಟಾರ? A2 ಯಾರ ಮದರ? ಮತ್ತೆ ಏನ್ ರೀಸನ್? ಮಾವ. ಏನ್ ರೀಸನ್ ಏನ್ ಹೇಳಿ? The petitioner is falsely implicated in the matter cannot be accepted at this stage. Having criminal antecedent admittedly having any criminal antecedents. Admittedly, investigation is completed and charge sheet is also filed. Therefore, detention of the petitioner court study would submit. ಇದು ಸೇಮ್ ನಿನ್ನೆ ಒಂದು ಯಾವ್ದೋ ಒಂದು ಆರ್ಡರ್ ಆಗಿತ್ತಲ್ಲ ಅದೇ ತರ. Investigation is completed and
the complainant who is with the folded hand before the court melon. She has been trying to get her innocent son to get him under the bail melon. He is the only male person who is looking after our
PM report copy ಹಾಕಿಲ್ವಾ? ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ PM report copy? Investigation complete ಆಗಿದೆಯಲ್ಲ? ಏನು PM report cause of death ಏನು? What is the cause of death? Head injury. ಮತ್ತೇನ ಹೊಟ್ಟೆಗೆ ಚಾಕು ಹಾಕಿದ್ರೆ ಹೆಡ್ ಇಂಜುರಿ ಹೆಂಗಾಯ್ತು?
ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಇಸ್ ವೆರಿ ಕಾಂಟ್ರಾ ದ ಕಂಪ್ಲೇಂಟ್ ಫ್ಯಾಕ್ಟ್ಸ್.
ಫುಲ್ಲಿ ಹೆಡ್ ಸ್ಟಮಕ್ ಅಬ್ಡಮನ್ ಏನು ಇಂಜುರೀಸ್ ಇಲ್ವಾ? ಹೋಗ್ಲಿ ಅಲಿಗೇಷನ್ ಏನು ಮತ್ತೆ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅಂತಿಮ ವರದಿ ಫೋಟೋ ಕಾಲಮ್ ನಂಬರ್ 17. ಕುಡಿದು ಬಂದು ಗಲಾಟೆ ಮಾಡಬೇಡ, ಬುದ್ಧಿ ಮಾತು ನೀಡಿದ ಕೈಯು ನಾನು ತಾನು ತನ್ನ ತಾತನಾದ 2 ಅವರ ಮನೆಗೆ ಹೋಗುತ್ತೇನೆ ಅಂತ ಹೇಳಿ ಅದೇ ದಿನ ರಾತ್ರಿ 7 ಗಂಟೆಯಲ್ಲಿ ಬುತ್ತ ಮುನೇಗೌಡ ಸಾಕ್ಷಿ 1 ಅವರನ್ನು ಹುಡುಕಿಕೊಂಡು 2 ಅವರ ಮನೆಗೆ ಬಂದಿದ್ದು. 2 ಆತನ ಮಗನಾದ ಮುನೇಗೌಡರನ್ನು ನೋಡಿ A2 ರವರು A1 ರವರನ್ನು ಕುರಿತು ನಿಮ್ಮ ಅಪ್ಪನ ನಿನ್ನನ್ನು ಹುಡುಕಿಕೊಂಡು ಇಲ್ಲಿಗೆ ಬಂದಿದ್ದ ಕಾಣಿಸು ಅಂತ ಹೇಳಿದಾಗ ಕೂಡಲೇ ಮನೆಯಲ್ಲಿದ್ದ ಚಾಕುವನ್ನು ತೆಗೆದುಕೊಂಡು ಒಂದು ಮನೆಯಲ್ಲಿ ಹೊರಾಂಡದಲ್ಲಿದ್ದ ಮುನೇಗೌಡರವರ ಬೆನ್ನಿನ ಹಿಂಭಾಗಕ್ಕೆ ಬಲವಾಗಿ ತಿವಿದು ತೀವ್ರ ಸ್ವರೂಪದ ರಕ್ತ ಗಾಯ ಮಾಡಿ ಕಾಲಿನಿಂದ ಜೋರಾಗಿ ಒದ್ದಿದ್ದರಿಂದ ಮುನೇಗೌಡನು ಹೊರಾಂಡದ ನೆಲದ ಕಲ್ಲಿನ ಮೇಲೆ ಬಿದ್ದು ಬಲಹಣೆಯ ಮೇಲೆ ಊತದ ಗಾಯವಾಗಿ ಕೊಲೆಯಾಗಿ ಮೃತಪಟ್ಟಿದ್ದು. ಸ್ಥಳದಲ್ಲಿ ಇದ್ದ ಸಾಕ್ಷಿ ಬೆನ್ನಲ್ಲಿ ಇಂಜುರಿ ಇದೆಯಾ ನೋಡಿ. ಸೌದೆಗಳ ಮೇಲೆ ತಳ್ಳಿದ್ದು ಮನೆಯಲ್ಲಿ ಇದ್ದ ಸಾಕ್ಷಿ 2 ಪಿಳ್ಳಕ್ಕರವರು ಮುನೇಗೌಡರವರಿಗೆ ಉಪಚರಿಸಿದ್ದು ಕೃತ್ಯವನ್ನು ಕಣ್ಣಾರೆ ಕಂಡ ಸಾಕ್ಷಿ CW3 4 ರವರು ಜಗಳ ಬಿಡಿಸಲು ಹೋದಾಗ A1 ಸಾಕ್ಷಿ 3 ಮತ್ತು 4 ನೀವೇನಾದರೂ ಅಡ್ಡ ಬಂದರೆ ನಿಮಗೊಂದು ಗತಿ ಕಾಣಿಸುತ್ತದೆ ಬೆದರಿಸಿದ್ದು. The petitioner counsel and auxiliary counsel appearing for the state. The factual matters of the case of the prosecution is that when this petitioner came to house with a drunken stage on 16/2/21 at around 6:30 p.m. between them, between him and the parents. And advised the A1 not to make any galata. And hence A1 left the house saying that he is going to his grandfather's house. But instead of he went to the house of A2. And when the CW1 and the deceased went in search of the accused number 1, went to the house of A2, and at that time A2 instigated accused number 1 not to leave them, and hence immediately the A1 took out the knife and assaulted on the back of the deceased, and the consequence he fell down on the stone. As a result, he had sustained head injury and he passed away. And this incident is witnessed by CW3 and 4 who were there at the spot. Based on the complaint, police have registered the case and invoked the offense on section 302, reduced section 34 of IPC, and police have investigated the matter and filed the charge sheet. The counsel appearing for the petitioner would submit that though prosecution is relying upon the eyewitnesses, and they have been planted witnesses and they were not there at the spot, and their statement also contradictory to each other. The counsel also submits that though prosecution case is that he inflicted with injury with knife, but the cause of death is on account of head injury and no connection to the stab injury as well as the head injury, and no allegation that he had inflicted injury on the head, and hence full stop. The counsel also submits that investigation has been completed and charge sheet also filed. No need of custodial trial. For counter, the counsel appearing for the petitioner state would submit that this petitioner is the son of the victim and he committed the murder of his own father. And that too, he stabbed on the back of the victim. And as a consequence, he fell down on the stone. As a result, he had sustained injury to his head. And cause of death is also on account of head injury. And hence, there is a prima facie case against the petitioner. The counsel also submits that there are eyewitnesses, particularly CW3 and 4, who have witnessed the incident. And when the direct evidence is there and direct evidence is available, there is a prima facie case. Having heard the respective counsel and also on perusal of material available on record, the very case of the prosecution that on the same day, on 16/2/2021, when this petitioner went to house with the drunken stage, advised the CW1 as well as the deceased, but he went to the A2. Then the CW1 and deceased went in search of the son to the house of A2. And A2 instigated A1 to commit the murder. Under such circumstances, incident is taken place. Now the prosecution is mainly relying upon the evidence of eyewitnesses, that is CW1, 3 and 4. And apart from that, medical evidence also discloses that he had sustained head injury and cause of death also on account of head injury. The material collected by the prosecution is also clear that when this petitioner inflicted injury with knife and as a consequence, the deceased fell down on the stone and he had sustained injury to his head. And having taken material on record, when there is a prima facie evidence of prima facie eyewitnesses, witnesses, the cause of death also supports the case of the prosecution. It is not a fit case to exercise the discretion in favor of the petitioner. Completion of the investigation is not a ground when an heinous offense of taking the life of a person, that too the victim is a father of this petitioner.
The direction is given to the lower court to conclude that trial not obvious.
No such direction.
Given liberty to file at least bail application after conclusion of the material.
Right. Petition is rejected. However, liberty is given after the examination of material witnesses. 54. Anish Joseph. Ready. ಅಲ್ರಿ ಯಾವಾಗ ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿ ತಗೊಳ್ಳಿ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿರೋದಾ ಇಲ್ಲಲ್ಲ ಪಿಟಿಷನ್ ಇಸ್ ಫೈಲ್ಡ್ ಆನ್ 439B for modification of the custodian, then appropriate to grant a week's time ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಟೈಮ್ ಕೊಟ್ಟಿದೀವಲ್ಲ 4 to ಇವತ್ತಾಗ್ಲೇ 11th ಡೇಟ್ ಅಲ್ಲ ರೀ ಓನ್ಲಿ ಮಾಡಿಫಿಕೇಶನ್ ಆಫ್ ಕಂಡೀಷನ್ ಆಲ್ಸೋ. Respondent counsel seeks 2 days time to file objections. Finally granted 2 days time. List this matter Monday, Tuesday, louder put him 16th. Wednesday.
Sorry for the intervention.
ಹೇಳ್ರಿ ಮ್ಯಾಟರ್ ನೋಡಿ ನೀವು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಮುಂದೆ ಹೋಗಿದೆ ಪಾಸ್ ಓವರ್
ವಿಡಿಯೋ ಡಿಸ್ಟರ್ಬೆನ್ಸ್
ಆಯ್ತು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ವೆಯ್ಟ್ ಮಾಡ್ಬೇಕು ನೀವು ಬಂದಾಗ ತಗೊಳಕ್ಕಾಗಲ್ಲ ಕೇಸ್ನ ಆಯ್ತು ನೆಕ್ಸ್ಟ್
ಅದಲ್ಲ ಸ್ವಾಮಿ 44 ಅಲ್ಲಿ
ವೇಟ್ ಮಾಡ್ಬೇಕ್ರಿ ಕೌನ್ಸಿಲ್ ವೇಟ್ ಮಾಡ್ಬೇಕು ಈಗ ಆಲ್ರೆಡಿ ನಾವು ಆರ್ ಇನ್ ಸೀರಿಯಲ್ ನಂಬರ್ 55 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಟೇಕ್ ಅಪ್ ಯುವರ್ ಮ್ಯಾಟರ್ ಆಲ್ಸೋ
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್ ಪ್ಲೀಸ್
376 IPC 3456 IPC ಆಕ್ಟ್
ಆಯ್ತು ಇವನ್ಯಾರು ಹೇಳಿ ಫಸ್ಟ್ ಇವನೇ A2 ನಾ A2
is a lady. One is the husband. Who is the lady? 3 is the customer. 4 and 5 are girls who procured the victims.
Your allegation is that you are running brothel.
Yes,
houda along with husband. Houda heli
honorable court has granted bail to the accused number 3.
That is because only on the ground that he is a customer. Houda that's all. No, next.
So my lord,
ground heli they are minor girls. Houda minor girl are subjected to sexual act in the brothel run by you.
My lord, section 376 and 370 does not respect.
ಆಯ್ತು ರೀ, ಅದ್ ಬೇಡ, ಬೇರೆ ಹೇಳಿ. 370 ಅಟ್ರಾಕ್ಟ್ ಆಗ್ತದೆ, ಯಾಕೆ ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ಲ? ಟ್ರಾಫಿಕಿಂಗ್
4 and 5 would compute the minor girl.
4 and 5 may be in whose place they were subjected to sexual act.
Husband
Ah.
has is the right.
How you are telling that 370 not attracts?
Because the 4 and 5, the statement of the victim, my lord, she states that is the accused number 4 who has brought her from a native place.
Maybe they brought.
And my lord, the husband is the rental agreement holder of the property. The wife is staying with him. There are 2 kids also, my lord.
Maybe kids.
Mentioned and all names are not mentioned. More than 100 days that my lord is in custody now. But
370 subclass 4. Wherein the offense involves the trafficking of a minor, it shall be punishable with rigorous imprisonment for which shall not be less than 10 years, but which may extend to imprisonment for life and shall also be liable to fine. 370 subclass 4.
So that she
ಆಕೆ ಅದು ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ? ಅವಳ ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದಿರಲ್ಲ, 164 ಸ್ಟೇಟ್ಮೆಂಟ್. ಅವ್ರ ಫೈಲ್ ಹಾಕಿ ಕೇಳ್ತಾರೆ, ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವ ಫೈಲ್ ಅಲ್ಲಿ? What is the age of the victims? 17
years 9 months.
17 years 9 months. What section 2D of POCSO Act says? Section 2D, below the age of girl below the age of 18. 2D of POCSO Act. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅಲ್ಲ? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಏನ್ರಿ? ಇಲ್ಲಿದೆ ಚಾರ್ಜ್ ಶೀಟ್. ಓಕೆ.
I filed a memo along with
ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ them.
memo with the charge.
ಲೇಡಿ ಆದ್ರೇನ್ರಿ? ಲೇಡಿ ಆದ್ರೇನು? ಸಣ್ಣ ಮಕ್ಕಳನ್ನ ಪ್ರಾಸ್ಟಿಟ್ಯೂಷನ್ ಗೆ ಮಾಡಿಸ್ತೀರಿ ಅಂತಂದ್ರೆ ಲೇಡಿ ಇಸ್ ಇಟ್ ಎ ಗ್ರೌಂಡ್ ಫಾರ್?
ಗಂಡನೊಟ್ಟಿಗೆ ಮಕ್ಕಳೊಟ್ಟಿಗೆ ಮನೆಯಲ್ಲಿ ಇದ್ರು ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಇಟ್ ಇಸ್ ದಿ ಹಸ್ಬೆಂಡ್.
ಮನೆಯಲ್ಲಿ ಇದ್ರು ನಡೆದಿದ್ದೆಲ್ಲಿ ಇದೆಲ್ಲ? ಆಕ್ಟ್ ಎಲ್ರಿ ನಡೆದಿದ್ದು?
ಅಪಾರ್ಟ್ಮೆಂಟ್.
Apartment belongs to whom?
Owner, my lord. Owner is one. The rental agreement also, which is
rental agreement with whom ರೀ? ಮತ್ತೆ ಹುಡುಗಿಯರು ಮತ್ತು ಅಪ್ರಾಪ್ತ ಹೊರ ಜಿಲ್ಲೆಗಳಿಂದ ಕರೆದುಕೊಂಡು ಹುಡುಗಿಯರನ್ನು ಕರೆಸಿಕೊಂಡು ಅವರುಗಳು ಅಕ್ರಮವಾಗಿ ಇಟ್ಟುಕೊಂಡು ವೇಶ್ಯಾವಾಟಿಕೆ ದಂಧೆಯನ್ನು ನಡೆಸಿಕೊಂಡಿದ್ದು ನಮೂದಿಸುವ ಸೋನ್ಸು ಅಪ್ರಾಪ್ತ ಬಾಲಕಿಯನ್ನು ಗೊತ್ತಿದ್ದ ವೇಶ್ಯಾವಾಟಿಕೆ ದಂಧೆಗೆ ಕರೆದುಕೊಂಡು A3 ಆರೋಪಿಯನ್ನು A2 ಆರೋಪಿಯು ಈಕೆ A2ನಾ? ಈಕೆನ ಮನೆಗೆ ಬರಮಾಡಿಕೊಂಡು A3 ಆರೋಪಿಯಿಂದ ಹಣ ದುಡ್ಡೆಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡಿರೋದೆಲ್ಲ ಈಕೆನ ಎಲ್ಲ ಆಲ್. ಅದೇ ಬ್ರೋತೆಲ್. And you only collected the money.
My lord, one more.
ಹೇಳಿ.
ಇದರಲ್ಲಿ section 15 immoral trafficking act, my lord, is also not adhered to. Search without warrant. Before making the search under.
ಅದೆಲ್ಲ matter of trial.
Yes.
That is a matter of trial, not at the time of considering the non-compliance. All are at the time of trial only.
May be taken under
That is
4 years and 7 years.
Not to the fact. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that A1 and A2 both are husband and wife, and they are running brothel, securing the minor girl through accused number 4 and 5. And when the raid was conducted, the A3 was the customer on 22/10/2021 and apprehended the accused persons, and also the CW2, who is the minor, was subjected to sexual action. Hence, all of them have committed the offences punishable under section 4, 6 and 17 of POCSO Act, as well as section 3, 4, 5, 6 of ITP Act, and also section 370, 376, read with section 149 of IPC. The counsel appearing for the petitioner would submit that this petitioner is a woman, and offence under section 370, 376, read with section 149 of IPC not attracts against this petition. At the most, it attracts section 3, 4, 5, 6 of the ITP Act. Hence, and already this court has granted bail in favor of accused number 3, and hence This petition may be enlarged on bail. The counsel also submits that already investigation has been completed and no need of custodial trial. The offence is not punishable with the death or imprisonment for life. The counsel appearing for the state would submit that this petitioner only collected the money from accused number 3 and subjected the CW2, knowing fully well that CW2 is a minor girl for sexual act and she is running a brothel along with accused number 1. Hence, there is a prima facie case against the petitioner herein. And heard the petitioner counsel and also the counsel appearing for the state and also looking into the material available on record. Raid was conducted on 22/10/2021. And minor girl who is aged about 17 years was subjected to sexual act, that too in the house of A1 and A2. And the case of the prosecution also that A1 and A5 procured the CW2, knowing fully well that CW2 is the minor. Apart from that, specific allegation is made against this petitioner that she only collected the money from accused number 3 and subjected CW2 minor girl for sexual act and she is running the brothel. When such specific allegations are made, when the offence of 370 is also invoked, which prescribes the sentence for 10 years and also can be extended for life imprisonment. And particularly the victim CW2 is a minor who is aged about 17 years and hence offence also invoked under section 4617 of POCSO Act. When considering the factual aspects and material on record, and when the prima facie case is against this petitioner, it is not a fit case to exercise the discretion in favor of this petitioner. The very contention of the petitioner counsel that the petitioner being the lady and she may be enlarged on bail. And specific allegation is made against her that she only collected money from A3 and knowing fully well subjected the minor girl for sexual act. And when such heinous allegation, heinous offence is committed, it is not a case to exercise the discretion. Then liberty and liberty 6 months alla. I will not pass any such order time limit. Aita Ali court cases ಎಷ್ಟು ಇರುತ್ತದೆ ಯಾರಿಗೆ ಗೊತ್ತು. ಒಂದೊಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೋಕ್ಸೋ ಕೇಸು 300 400 200 ಇದೆ. ಕಾನೂನು ತಯಾರು ಮಾಡೋರು ಮಾಡಿಬಿಡ್ತಾರೆ, 1 ತಿಂಗಳೊಳಗೆ ಟ್ರಯಲ್ ಮುಗಿಸಿ ಅಂತ. ಅವ್ರಿಗೇನ್ ಗೊತ್ತಾಗಬೇಕಲ್ಲಿ ಕೂತ್ಕೊಳ್ಳೋರಿಗೆ, ಗೊತ್ತಿದ್ದವ್ರಿಗೆ ಗೊತ್ತಾಗೋದು ಕಷ್ಟ. 1 ತಿಂಗಳೊಳಗೆ ಟ್ರಯಲ್ ಮುಗಿಸ್ಬೇಕು ಅಂತ ಬರೀತಾ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅಲ್ಲಿ ಬರೀತಾರೆ. ಅವ್ರಿಗೇನ್ ಗೊತ್ತಾಗಬೇಕು ಹೇಳಿ ಸೆಕ್ಷನ್ 35 ಅಲ್ಲಿ. ರಿಜೆಕ್ಟೆಡ್. Asha Devi, yes, A5 120B 394 397. Okay. Pass over, note. He seeks time, he is getting records. Abhishek, and then. Office objection and office objection raised on copy of Panchanama. ಆಯ್ತು, ಪಂಚನಾಮದ್ದೇನು ಹಾಕಿದಿರಾ ನೀವು? ಪಂಚನಾಮ ಏನ್ರಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್? ಕಾಪಿ ಶುರು ಮಾಡಿಲ್ಲ ಅಂತ. ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇದೆಯೇನ್ರಿ? ರೆಕಾರ್ಡ್ ತರ್ಸ್ಕೊಂಡಿದಿರಲ್ಲ, ಹೇಳಿ ಕೇಸ್ ಏನ್ ಹೇಳಿ? ಸೀಸರ್ ಮಾಜರ್ ಕ್ವಾಂಟಮ್ ಏನ್ ಹೇಳಿ ಫಸ್ಟ್? ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಆಯ್ತು, ಕ್ವಾಂಟಮ್ ಏನು?
Quantum alert from petitioner number 1 is the accused number 1. From him 5 gram of MDMA.
MDMA 5 gram.
5 gram. And from petitioner number 2 is the accused number 3 in the same case. From
accused number 3. ಹೌದಾ? ಅವನಿಂದ ಎಷ್ಟು?
5 gram.
ಅವನು 5 gram.
Yes. And from accused number 2 there is 11 gram of MDMA is recorded.
11 ali 21 gram.
Yes,
total
quantity is 20 gram.
21 gram. 11 plus 5 1 plus 5.
Yes, my lord. From this petitioner 5 gram each, my lord.
ಆಯ್ತು. ಏನ್ರಿ ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಇದೆಯಾ? ಇಲ್ವಾ? ಬಟ್ ರಿಕವರಿ 5 ಸಪರೇಟ್ ಅಂದ್ರೆ ಹೇಗೆ? ವೇರ್ ದೇ ವರ್ ದೇರ್?
They were in Nimishamba hospital. Nimishamba Indaya number 43 or 49.
ಮನೆಯಲ್ಲಿದ್ರಾ?
ಟೆರಸ್ ಅಲ್ಲಿ ಅಂತ.
ಟೆರಸ್ ಅಲ್ಲಿ ಏನು ರೂಮಾ ಏನು?
Accused number 1 room ಅಂತ ಹೇಳ್ತಾರೆ.
And perusal search of accused, they seized 10 grams of MDA crystals and 11 grams of MDA ecstasy. Total seizure Panchanama was done, therefore details so.
The memo, I have filed a memo on 9th, my lord. In that the segregation separate seizure is shown in the said.
Separate seizure.
Yes, my lord.
Separate seizure in a house. House belongs to the accused number 1.
as per the
Raid was conducted
the terrace floor,
which belongs to A1.
A1 ಅಂತ.
ಹೌದಾ? All are there together. ಹೌದಾ? That is by personal search, but all of them were there. ಹೌದಾ?
Last 83 days they are in custody.
83 days. ಆಯ್ತು ನೋಡೋಣ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 21/11/2021 at about 12 hours, an information is received at house number 43/49, Sri Nimishamba Nilaya, Netravarti Extension, KR Puram, Bangalore. 3 persons are storing the drugs and selling the same to ITBT employees and public. On information, conducted the raid and made the search on personal search. Grams of MDMA seized at the instance of accused 3, accused number 2, and 5 grams each from accused number 1 and 3. The accused number 1 and 3 are the petitioners before this court, and total MDMA is 10 grams, and in total MDMA seized is 21 grams. And matter is under investigation. The counsel appearing for the petitioner submits that only 5 grams of MDMA is seized at the instance of this petitioner, and also not complied with the provisions of the NDPS Act while conducting the seizure, and alleged seizure is also doubtful. And there are no any criminal antecedents against these petitioners, and hence they may be enlarged on bail. For contrary, the counsel appearing for the state would submit that total 20 grams of MDMA is seized at the instance of all the accused persons who are there in the house. And the total quantity 21 grams, which is the commercial quantity, and matter is under investigation, and at this stage they are not entitled for bail. Having heard the respective counsel and also on perusal of material, it discloses that the raid was conducted in respect of the house number 43/19, wherein all these petitioners were apprehended, and while apprehending them also 21 grams of MDMA was seized. No doubt on personal search, 5 grams of MDMA is seized at the instance of accused number 1 and another 5 grams from accused number 3. In total, 10 grams from these two petitioners, and the MDMA is a manufactured drug and not the narcotic substances. And when such being the case, when the total quantity of 21 grams is seized at the instance of all the accused, that is a commercial quantity. And hence, it is not appropriate to enlarge them on bail during the crime stage. And charge sheet is not yet completed, and hence not a fit case to exercise the discretion at the crime stage, and hence dismissed. The liberty is rejected. Liberty is given to approach this court after filing of charge sheet. 58 Manjunatha N 8224 and 9. Yes, counsel.
My colleague name is mentioned in place of my name.
ಆಯ್ತು, ನೀವು ಸೈನ್ ಮಾಡಿಲ್ವಾ? ನಿಮ್ದು ಸಿಗ್ನೇಚರ್ ಇದೆಯಲ್ಲ? ಆಯ್ತು, ಸಾಕು. Go to page 29, charge sheet.
Yes, sir. Lordship, you can see. A3 names is not reflected in the FIR. A4. Lordship, you can see A4 name is not reflected.
A4 not in the FIR.
Yes. Lord, A9 name is mentioned by the complainant. ಬ್ರಹ್ಮದಲ್ಲಿ ನಾನು ಅವರ ಹೆಸರು ಹೇಳಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಭ್ರಮೆಯಲ್ಲ, ಬ್ರಹ್ಮದಲ್ಲಿ. A9
ಹೆಸರು ನಾನು ಹೇಳಿದ್ದೀನಿ, ಅವ್ರ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Your Lordship, please can you see the deceased, Your Lordship, is Darar, one Mr. Darar, who has got, my Lord, 2 murder cases. Can you see the page number 15, complaint, my Lord. Complaint. Second para, my Lord, he specifically is the brother of the deceased, who lodged complaint on 7/8/21, who stated that ನನ್ನ ಅಣ್ಣ ಮಜರ್ ಖಾನ್ ಬಟ್ಟಿ ನಗರ್ 39 ವರ್ಷ, ಇವರು ಹೆಂಡತಿ ನಾದಿನಿ ಖಾನಂ, ಸಾದಿಯಾ ಖಾನಂ 6 ಜನ ಮಕ್ಕಳೊಂದಿಗೆ ನಮ್ಮ ಕಟ್ಟಡದಲ್ಲಿ ಇರುವ ಮತ್ತೊಂದು ಮನೆಯಲ್ಲಿ ಸಂಸಾರ ಸಮೇತವಾಗಿ ವಾಸವಿದ್ದು ಶಿವರಾಜ್ ರಸ್ತೆಯ 2ನೇ ಕ್ರಾಸ್ ಫರ್ನಿಚರ್ ಮಾಡುವ ಕೆಲಸವನ್ನು ಮಾಡುವ ಸುಮಾರು 15 ದಿನಗಳಿಂದ ಮಾಡಿಕೊಂಡು ಇದ್ದಾರೆ. ಮಜರ್ ಖಾನ್ ಹೂ ಇಸ್ ದಿಸ್ ಇಸ್ ಮಲಾಡ್ 2016 ವರ್ಷದಲ್ಲಿ ಹೀಗೆಹಳ್ಳಿಯ ಇದ್ರೀಸ್ ಕೊಲೆ ಕೇಸಿನಲ್ಲಿ ಹಾಗೂ 2017ನೇ ವರ್ಷ ಪಿಳ್ಳನಗಾರ ವಾಸಿ
ಚೋಟನ್
ಅವರು ಜೈಲಿನಲ್ಲಿ ಬೇಲ್ ಆಗಿರುತ್ತದೆ. 7/8/2021 ಬೆಳಿಗ್ಗೆ 8:15 ಗಂಟೆಯ ಸುಮಾರು ನಮಗೆ ಪರಿಚಯವಿರುವ ಶಫಿ ಅಹಮದ್ ಮನೆಗೆ ಬಂದು ಶಿವರಾಜ್ ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿರುವ ಬತ್ತಿ ಫಿರೋಜ್ ಮತ್ತು ಆತನ ಮನೆಯವರು ಮಜರನನ್ನು ಅವರ ಮನೆಯ ಕಾಂಪೌಂಡ್ ಒಳಗಡೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಮಾರ್ಗಸ್ಥರಗಳಿಂದ ತಲೆ, ಕುತ್ತಿಗೆ ಮತ್ತು ಕಾಲಿಗೆ ಹೊಡೆದು ಕೊಲೆ ಮಾಡಿ ರಸ್ತೆಯ ಮೇಲೆ ಬಿಸಾಡಿರುತ್ತಾರೆ. ತಿಳಿಸಿದ ತಕ್ಷಣ ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನೋಡಿದಾಗ ನನ್ನ ಅಣ್ಣ ಮಜರ್ ಖಾನ್ ಶಿವರಾಜ್ ರಸ್ತೆಯಲ್ಲಿ ಬಿದ್ದಿದ್ದ ಅದರ ಕುತ್ತಿಗೆಗೆ ಮಾರ್ಗಸ್ಥರಗಳಿಂದ ಕೊಯ್ದು ದೊಡ್ಡ ಆಯುಧಗಳಿಂದ ಹೊಡೆದು ಗಾಯಗಳು ಮತ್ತು ಬಲಗಾಲಿಗೂ ಹೊಡೆದು ಗಾಯ ಆಗಿರುತ್ತದೆ. ನಂತರ ಏನಾಯ್ತೆಂದು ಶಫಿ ಅಹಮದ್ ಮತ್ತು ಸ್ಥಳದಲ್ಲಿ ಇದ್ದ ಮೊಹಮ್ಮದ್ ಬಶೀರ್ ಅವರ ಬಳಿ ಕೇಳಿದಾಗ ಈ ದಿನ ಬೆಳಿಗ್ಗೆ 8 ಗಂಟೆ ಸುಮಾರಿಗೆ ಮಜರ್ ಖಾನ್ ಶಿವರಾಜ್ ರಸ್ತೆಯ ಬಂದು ರೇಷ್ಮಾ ಜೊತೆ ಗಲಾಟೆ, ರೇಷ್ಮಾ ಅಂತ ಹೇಳಿದ್ರೆ A1 ರೇಷ್ಮಾ ಜೊತೆ ಗಲಾಟೆ A1 ಗ್ರಾಂಟೆಡ್ ಬೇಲ್ ಜೊತೆ ಗಲಾಟೆ ಮಾಡುತ್ತಿರುವಾಗ ರೇಷ್ಮಾ ಮಗ ಶಹಬಾಜ್ ಮೆಲಾಡ್ A9 ಮನೆಗೆ ಬಂದು ಮಹಾಜರನನ್ನು ಮನೆಯ ಗೇಟ್ ಒಳಗಡೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿದ್ದ ಸಾಕಿಬು ಅಲಿ ಮುಸ್ತಾಕ್, ಫೆರೋಜ್ ಮತ್ತು ರೇಷ್ಮಾ, ಸಮೀನಾ ಮತ್ತು ಹಸೀನಾ ಇತರರು ಸೇರಿಕೊಂಡು ಮಾರ್ಗಸ್ಥರಗಳಿಂದ ಮಜರ್ ಖಾನ್ ತಲೆ, ಕುತ್ತಿಗೆ ಮತ್ತು ಕಾಲಿಗೆ ತಿವಿದು ಸಾಯಿಸಿ.
How many injuries? A1 and A7 and A8.
A7 and A8 by the Honorable Court in criminal petition number 7570.
ಅಲಿಗೇಷನ್ ಏನು ಅವ್ರ ಮೇಲೆ ರೀಸನಿಂಗ್ ಏನು
ಅವರು ಗಟ್ಟಿಯಾಗಿ
ಹಿಡ್ಕೊಂಡಿದ್ರು ಅಂತ ಹೇಳ್ದಂತ.
A1 role is there, specific role is there A1, but Honorable Sessions Court Malad granted bail.
A1 ಗೆ
yes
A1 ಗೆ ಏನು ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್?
Specific allegation how she is also involved and participated in the commission of offense. Lordship, please can you see the page number 38?
ಎಲ್ಲಿ ಆರ್ಡರ್ ಇದೆಯಾ ಅದು? A1 ಗ್ರಾಂಟ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ಇದೆ. ಆರ್ಡರ್ ಕಾಪಿ ಹಾಕಿದೀರಾ?
Page number 17 Malad.
17
And your Lordship, please can you see the page number?
ಇದರಲ್ಲೆಲ್ಲ ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. A1 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು, A1 ಕೊಟ್ಟಿದ್ದಾರೆ. But your Lordship, please can you see
A1 ಹೆಣ್ಮಗಳ?
ಹೌದು.
ಯಾರು A1 ಹೆಸರೇನು? ರೇಷ್ಮಾ ಲೇಡಿ ಮುಂದಿನ ಆರೋಪಿತ. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ A6 ಮಾಡಿದಾರಾ? A6 ಮೇಲೆ ಏನು ಅಲಿಗೇಷನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ? ಅಷ್ಟೇನೆ 5-6 ರೂಪಿಸಿಕೊಂಡು ಮಾದಕವನ್ನು ಆತನ ಕಟ್ಟಿಕೊಂಡು ಒಂದು ಆರೋಪಿತ ಮಜರ್ ಖಾನ್ ಬಿಗಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡಾಗ 7 and 8 ಓನ್ಲಿ ಹೆಲ್ಡ್ ಅಂತ. A1, A7, A8 ಹೆಲ್ಡ್, ಓನ್ಲಿ ಹೆಲ್ಡ್ ಅಂತ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್
page number
39
ಪಂಚ ನಾನು ಮೇಲೆ ತಿಳಿಸಿರುವ
ಪಂಚದಲ್ಲ ಏನ್ ಬೇಕಾಗಿಲ್ಲ, ಅದು ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್. ಈಗ ಅದನ್ನೆಲ್ಲ ಓನ್ಲಿ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಸೀ ದಿ ಪೇಜ್
number
ಏನಾರ ಐ ವಿಟ್ನೆಸಸ್ ಇದಾರಾ? ಓನ್ಲಿ ಸರ್ಕಮ್ಸ್ಟೆನ್ಷಿಯಲ್ ವಿಟ್ನೆಸಸ್. CW 12 to 14.
These are the witnesses, my lord, where they shown as a inquest. Your lordship is
39.
ನಾನು ಮೇಲೆ ತಿಳಿಸಿರುವ ವಿಳಾಸದಲ್ಲಿ ಮಾತನಾಡಿಕೊಂಡು ಆಟೋ ಡ್ರೈವರ್ ಆಗಿ ಜೀವನ ಮಾಡಿಕೊಂಡು ನನಗೆ ಮೃತ ಮಜರ್ ಖಾನ್ 39 ವರ್ಷ, ಇತನು ಸ್ನೇಹಿತನಾಗಿರುತ್ತಾನೆ. ಈಗ ದಿನಾಂಕ 7/8/2025 ಬೆಳಗ್ಗೆ ಸುಮಾರು 8:25 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಅಲ್ಲಿ ಅಂಡು ಎಂಬವರು ದೂರವಾಣಿ ಕರೆ ಮಾಡಿ ಮಜರ್ ಖಾನ್ ಎಂಬುವರಿಗೆ ಶಿವರಾಜ್ ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿ ಯಾರೋ ಮಚ್ಚಿನಿಂದ ಹೊಡೆದಿದ್ರು.
ಯಾವ್ದ್ರಿ ನೀವು ಯಾರ್ದು ಅವ್ರ ಎಷ್ಟ್ರಿ? ಅವರು CW ಎಷ್ಟ್ರಿ ಅವರು?
CW
ಯಾರ್ದು ಓದ್ತಾ ಇದೀರಿ ನೀವು? ಹೆಸರು ಹೇಳಿ ಹೋಗ್ಲಿ.
ರೆಹಮತುಲ್ಲಾ.
ರೆಹಮತ್ತುಲ್ಲಾ. ಅವನು ಎಷ್ಟನೇ ಅವನು ವಿಟ್ನೆಸ್? CW ನಾಡೇನ ಐ ವಿಟ್ನೆಸ್ ರೀ. ಯಾವ್ದಾವ್ದೋ ಓದ್ತೀರಿ ಸುಮ್ನೆ. ಪ್ರಕರಣದ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿದಾರ ನೋಡಿ, ಶ್ರೀಮತಿ ಸಾದಿಯಾ ಖಾನಮ್ಮು, ಅಬ್ದುಲ್ ಜಬ್ಬಾರು, ಬಸೀರ್ ಅಹಮದ್. ಅದ್ ಬಿಟ್ಟು ಯಾವ್ದೋ ಬೇರೆ ವಿಟ್ನೆಸಸ್, ಮಾಜರ್ ವಿಟ್ನೆಸ್ ಎಲ್ಲ ಓದ್ತೀರಿ ನೀವು. ನೆಕ್ಸ್ಟ್ ಹೇಳ್ರಿ. PM ರಿಪೋರ್ಟ್ 19 injuries. Multiple injuries.
Page number 29, my lord. The name of the number 9. ನಾನು ಸುಳ್ಳಾಗಿ ನಾನು ನಮ್ಮ ಬ್ರಹ್ಮದಲ್ಲಿ ನಾನು ನನ್ನ ಅಣ್ಣ ಮಜಾರ್ ಖಾನ್.
ಪೇಜ್ ನಂಬರ್ ಎಷ್ಟು? ಪೇಜ್ ನಂಬರ್
29, my lord.
29.
Further statement of the complainant, my lord.
ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪೊಲೀಸ್ನವ್ರು ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಳ್ಳೋದು.
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ, my lord. ನಾನು ನನ್ನ ಅಣ್ಣ
29 ಅಲ್ಲಿ ಇಲ್ವಲ್ರಿ? 29 ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಇರೋದು.
ಪೇಜ್ ನಂಬರ್ 46, 46.
ಒಂದ್ಸರಿ 29 ಅಂತಾರಿ, ಒಂದ್ಸರಿ 46 ಅಂತಾರಿ. ಏನಿದೆ? ಫಿರ್ಯಾದುದಾರ ಮರು ಹೇಳಿಕೆ.
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ, my lord.
ದಿಗ್ಭ್ರಮೆಗೆ ಒಳಗಾಗಿ ರೇಷ್ಮಾ ಮಹಗ ಸಹಜ ಇದ್ದಾನೆಂದು ಹೇಳಿದ್ದೇನು. ನನ್ನ ಅಣ್ಣ ಮಣ್ಣಿನ ಕಾರ್ಯ ಮುಗಿದ ನಂತರ ಘಟನೆ ಬಗ್ಗೆ ಶಫಿ ಮಹಮ್ಮದ್. ಏನ್ರಿ ಇದು? ಫರ್ದರ್ ಹೇಳಿಕೆನಲ್ಲಿ ಐ ವಿಟ್ನೆಸ್ ಏನ್ ಹೇಳ್ತಾರೆ? CW 12 to 14. ತೊಳಿ. Or the petitioner counsel and also the counsel appearing for the state. These petitioners are accused number 2 to 4 and 9. And case of the prosecution is that on 6/8/2021, the accused persons conspiring with other accused persons, forming an unlawful assembly to the deceased near the old Madras soap factory, compound of house number 368, and accused number A1, A7 and A8 held the deceased tightly and snatched the knife from the Major Khan from A2 and inflicted the injury with knife. And when the victim screamed at the spot, A1 and A7 forcibly closed the mouth and made him to fell on the ground. And A3 inflicted injury with machete on his head and also on his neck. And accused number 4 also with the other machete inflicted injury on his back. And accused number 6 also inflicted injury. And A7 snatched the machete from A6. And destroyed the evidence. And accused number 9 conspired with other accused persons in taking the life of the victim. The counsel appearing for the petitioner would submit that A4 name is not found in the FIR. And this court already granted bail in favor of accused number 6, 7 and 8. And the investigation has already been completed. Counsel also submits that in the further statement of the complainant, statement is made that only by mistake named the mistake mentioned the name of accused number 9. No prima facie material against the petitioners and no need of custodial trial. Hence, they may be enlarged on date. Per contra, the counsel appearing for the state would submit that A2 only took the victim to a particular place and specific vote act allegation is made against accused number 3 and 4 as well as accused number 9. The eyewitnesses CW 12 to 4 specifically mentioned the name of vote act of accused number 9 also. At this stage, court cannot consider the further statement of complainant. When the eyewitnesses speaks with regard to the very participation, the accused number 9 also in committing the murder. The offense is also an heinous offense and there were 19 injuries and cause of death also on account of multiple injuries. And is not entitled for bail. Having heard the respective counsel and also on perusal of material available on record, particularly in criminal petition number 7570 of 2021, when the discretion is exercised in favor of accused number 7 and 8, this court has observed that no vote act alleged against these petitioners, except they also pushed down the deceased with other accused, joined with deadly weapons. And hence discretion is exercised. The case of the prosecution also that A6, A7 and A8 held the victim, but specific vote act allegation is made against accused number 2 to 4, inflicting injury with the deadly weapons like knife and machete. And also the CW 12 to 14 also in their statement before the police, who are the eyewitnesses, pointed out the role of A2 to 4 as well as accused number 4. And apart from that, 164 statement of these witnesses is also recorded before the learned magistrate. The cause of death also on account of 19 injuries sustained by the victim and a barbaric act is made with the deadly weapons like knife and machete. And cause of death on account of multiple injuries. When such being the heinous offense of committing the murder has taken place and when there are eyewitnesses, that is CW 12 to 14, it is not a fit case to exercise the powers of court. The order passed by this court in criminal petition number 7570 of 2021, exercising discretion in favor of accused number 7 and 8 will not come to the aid of the petitioners. Discussions made up, I pass the following order. Bail petition is rejected. Material witnesses ತುಂಬಾ ಇದಾರೆ ಆಗ್ಲಿ ನೋಡಿ ಆಮೇಲೆ ನೋಡಿ ಬರ್ಲಿ ಆಮೇಲೆ ನೋಡ ಬನ್ನಿ ಎವಿಡೆನ್ಸ್ ಆದ್ಮೇಲೆ ಬನ್ನಿ.
In serial number 59, my lord.
59, yes, counsel.
59, the counsel Abdul Ansar undertakes to file wakalat on behalf of the respondent, my lord.
Counsel?
Abdul Ansar, counsel Abdul Ansar.
Counsel Abdul Ansar undertakes to file wakalat on behalf of respondent, and hence if wakalat is filed, show the name of the counsel. List this matter on 21st.
Much obliged.
60 within. Reason for withdrawal. Trial court ಹೋಗ್ತೀರಾ? ಆಯ್ತು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೋಗಿಲ್ವಾ ನೀವು ಮುಂಚೆ ಬರಕ್ ಮುಂಚೆ ಇಲ್ಲಿಗೆ? ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು. Already have approached the trial court. Sessions court already have approached and rejected. ಹೌದಾ? Now we have filed this petition before this court. ಹೇಳಿ. Why you are withdrawing again to approach the trial court? ಎಲ್ಲಿದೆ ಆರ್ಡರ್? ಹೋಗಿಂತ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಅಲ್ಲೇನಾ? ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಎಲ್ಲ ಇದೆಯಾ? ಕೊಡ್ರಿ, ಫೈಲ್ ಕೊಡ್ರಿ ಮೇಡಮ್. ಪೇಜ್ ನಂಬರ್. ಯಾಕಂದ್ರೆ recently I noticed that when the Devanhalli court rejected the bail petition under section 438, a petition is filed before this court under section 438. and before me got it withdrawn and filed one more petition under section 438 at Coourt as well as at Mysore, creating an address. 438 petitions. How the advocates are stooped into the level of cheating the courts. That's why I'm asking the reasons. Where is the order? Annexure E, page number 28. 24, 25 order ಇದೆ ಇಲ್ಲಿ. Last order 25. With this observation necessary collect materials, no reasons ಅಂತ ಮಾಡಿದ್ದಾರೆ, dismiss ಮಾಡಿದ್ದಾರೆ. Case against the petitioner.
Last part of the order.
Custodial interrogation of the petitioner is necessary for collecting material for investigation ಅಂತಿದೆ. ಇಲ್ಲ operative portion ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. Directed to appear before the trial court and move regular bail application within 15 days from the date of order. ತೊಗೊಳ್ಳಿ. But ನಿಮ್ಮ ಮೆಮೊದಲ್ಲಿ ಬರೆದಿರೋದನ್ನ bail before the magistrate court. ತೊಗೊಳ್ಳಿ. Counsel appearing for the petitioner submits that petitioner is not pressing this petition and liberty may be given to approach the magistrate court for regular bail as observed by the session judge. In view of the submission, memo permitted to withdraw and liberty is given to approach the magistrate court. Yeah, fresh petition. Why again I have to give permission? ನೀವು ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದೀವಿ, ಹೋಗಿ ನಾನು ಆರ್ಡರ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬನ್ನಿ, ಇಲ್ಲಿ ಬರ್ತೀರಾ ಅಲ್ಲಿ ಬರ್ತೀರಾ ಸೆಷನ್ ಕೋರ್ಟ್ ಹೋಗ್ತೀರಾ ಹೋಗಿ. ಚಾಯ್ಸ್ ಇಸ್ ಯುವರ್ಸ್. ನೆಕ್ಸ್ಟ್ 61 ಉಮೇಶ್ ಮೂಲಿಮನಿ.
Appear for petitioner, my lordship.
Madam, ಹೇಳಿ.
Mulimani sir is out of station, my lordship.
Out of station is not the reason, madam. Argue.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲೇ ಲಾಗಿನ್ ಆಗೋದಕ್ಕೆ ಅಂತ ಫೈಲ್ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ. ನೆಟ್ವರ್ಕ್ ಪ್ರಾಬ್ಲಮ್ ಅಂತ ಹೇಳಿ. Kindly take it. Kindly. I have no file, my lordship.
No, madam. That is not a ground. Only two grounds.
My lord,
if is not feeling well.
ಅವ್ರ ರಿಲೇಟಿವ್ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದಾರೆ ಅಂತ ಹೇಳಿ ನೋಡ್ಲಿಕ್ಕೆ ಹೋಗಿದ್ರೆ ಸ್ವಾಮಿ.
ರಿಲೇಟಿವ್ ಆಸ್ಪತ್ರೆ ರಿಲೇಟಿವ್ ನೋಡ್ಕೊಂತಾರೆ. ಈಗ
ನೆಟ್ವರ್ಕ್ ಪ್ರಾಬ್ಲಮ್
ಮಾಡ್ತೀರಾ ಇಲ್ವಾ? ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಲಾ?
ನೆಟ್ವರ್ಕ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕಾಲ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಫೈಲ್ ಅವ್ರ ಕಡೆಗಿದೆ ಸ್ವಾಮಿ.
ಹೇಳ್ರಿ, ನೀವ್ ಹೇಳ್ರಿ. Ballistic report pending. Gunshot.
My lord, kindly take it Tuesday, my lordship.
No, madam. I spent my time also already. ಆಯ್ತು ರೀ, ಏನ್ರಿ ಗನ್ಶಾಟ್ ಏನ್ ಮಾಡಿರೋದು? ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ. ನೋಡಿ ಮೇಡಮ್, ಏನೋ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಆಗ್ತಾ ಇದೆ ಯಾರಿಂದಲ್ಲ. One second, charge sheet, ದೋಷಾರೋಪಣ ಪತ್ರ. ಇವನ್ ಎಷ್ಟು? ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಅಲ್ಲ, ಇವನ್ A2. A2 ಆರೋಪಿಯಾದ ಪೃಥ್ವಿರಾಜ್ ಸಿಂಗ್ ಕರೆದುಕೊಂಡು ಮೂಲ್ ಸಿಂಗ್ ನನ್ನು ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶವನ್ನು ಇಟ್ಟುಕೊಂಡು ಪರವಾನಗಿ ಇಲ್ಲದ ಹೌದಾ ಅಕ್ರಮವಾಗಿ ಗುಂಡು ತುಂಬಿದ 2 ಪಿಸ್ತೂಲ್ಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಸೋನ್ಸೋ ನಂಬರಿನ TVS ಬೈಕ್ ನಲ್ಲಿ ಹೊಳಲ್ಕೆರೆ ಟೌನ್ ಬಂದು ತನ್ನ ಅಂಗಡಿಯಿಂದ ಹೊರಬರುವುದನ್ನು ಕಾಯ್ತಾ ಕುಳಿತಿದ್ದು. ದಿನಾಂಕ 17/8 ರಾತ್ರಿ ಸುಮಾರು 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಮೂಲ್ ಸಿಂಗ್ ತಂದೆ ರಾಮ್ ಸಿಂಗ್ ಇವನು ತನ್ನ ಅಂಗಡಿಯ ಪೂಜೆ ಮಾಡಲೆಂದು ಅಂಗಡಿಯ ಹೊರಗಿನ ಫುಟ್ಪಾತ್ ಮೇಲೆ ಕುಳಿತುಕೊಂಡು ಮೆಣಸಿನಕಾಯಿಗಳನ್ನು ಸುಡಲು ತಯಾರಾಗುತ್ತಿದ್ದಾಗ ಹಿಂದಿನಿಂದ ಅಂದರೆ ಅನ್ನಪೂರ್ಣೇಶ್ವರಿ ಹೋಟೆಲ್ ಗುಂಡು ತುಂಬಿದ ಪಿಸ್ತೂಲ್ಗಳನ್ನು ಕೈಯಲ್ಲಿ ಹಿಡಿದುಕೊಂಡು ಫುಟ್ಪಾತ್ ಮೇಲೆ ನಡೆದುಕೊಂಡು ಬಂದು ಹೊಳಲ್ಕೆರೆ ಮುಖ್ಯ ವೃತ್ತ ಮಾಡಿ ಪೂಜೆ ಮಾಡಲು ಕುಳಿತಿದ್ದ ಮೂಲ್ ಸಿಂಗ್ನ ತಲೆಯ ಹಿಂಭಾಗಕ್ಕೆ A1 ಆರೋಪಿಯು ಒಂದು ಗುಂಡನ್ನು ಹಾರಿಸಿ ಕೊಲೆ ಮಾಡಿ ತಾವು ತಂದಿದ್ದ ಈ TVS ಅಪಾಚೆ ಬೈಕ್ ನಲ್ಲಿ ಬೀರೂರು ಟೌನ್ಗೆ ಹೋಗಿ ಅಲ್ಲಿ ತಮ್ಮ ಸ್ನೇಹಿತನ ಜಿಲೇಬಿ ಅಂಗಡಿಯ ಮುಂದೆ ಬೈಕ್ ಅನ್ನು ನಿಲ್ಲಿಸಿ A2 ಆರೋಪಿಯ ಸ್ನೇಹಿತನಾದ ತರೀಕೆರೆ ಗ್ರಾಮದ ಸಾಕ್ಷಿರವರ ಮನೆಗೆ ಬೈಕ್ ಅನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಇಟ್ಟುಕೊಳ್ಳುವಂತೆ ಹೇಳಿ ಬೀರೂರಿನ ತಮ್ಮ ಸ್ನೇಹಿತನ ರೂಮಿನಲ್ಲಿ ಕೃತ್ಯಕ್ಕೆ ಬಳಸಿದ ಪಿಸ್ತೂಲ್ ಹಾಗೂ ಗುಂಡುಗಳನ್ನು ಬಚ್ಚಿಟ್ಟು ಸಾಕ್ಷ್ಯ ನಾಶಪಡಿಸಲು ಪ್ರಯತ್ನಿಸಿ ರಾಜಸ್ಥಾನ ರಾಜ್ಯದ ಸ್ವಗ್ರಾಮಕ್ಕೆ ಹೋಗಿ ತಲೆಮರೆಸಿಕೊಂಡಿರುವುದು ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟ ಮೇಲ್ಕಂಡ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿ. ಇದೇನು ಯಾವ್ದೋ ಒಂದು ಆರ್ಡರ್ ಕಾಪಿಯನ್ನು ಹಾಕಿದಾರೆ ಅಲ್ಲಿ ಯಾರು? charge sheet has been filed and hence petitioner is intended to file fresh petition. Earlier got it rejected. Ballistic report is awaited. Yes, madam, ಹೇಳಿ ಗ್ರೌಂಡ್ಸ್ ಏನಾರ ಇದ್ರೆ ಹೇಳಿ, ನೀವು ಹೇಳಿದ್ರೆ ಕೇಳ್ತೀನಿ.
My lord, kindly pass over, my lordship. Kindly pass over, my lordship.
Why it has to be passed over?
File ಇಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲ,
ಓದ್ಕೊಂಡು
ಫೈಲ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅವರು ಊರಿಗೆ ಹೋಗಿದ್ದಾರೆ. ಫೈಲ್ ಅವ್ರ ಜೊತೆ
ನಿಮಗೆ ಆಮೇಲೆ 5 minutes.
ಫೈಲ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅವರಿಗೆ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ, ಲಾಗಿನ್ ಆಗ್ತಾರೆ.
ಯಾರಾದ್ರೂ ಆಯ್ತು. ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್, ದಟ್ಸ್ ಆಲ್. 62 ಗಜೇಂದ್ರ ಸಿವಿ. ಇದು ಕೂಡ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಕ್ವಾರಂಟೈನು, A3 ಕ್ವಾರಂಟೈನು, ಅರ್ಲಿಯರ್ ಆಲ್ಸೋ ಆಬ್ಸೆಂಟ್, ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ, ಬರ್ಲಿಲ್ಲ ಅಂತ. 63 ಎಂ ರಾಮಸ್ವಾಮಿ. 354, 506, 504, 323, 376. ಇಲ್ವಾ? ಪಾಸ್ ಓವರ್. ಆಮೇಲೆ ನೋಡಿ 64. 8 and 12. Hmm. 19. ಮೇಲಿಂದ ಓದೋದು ಬೇಡ, ಓನ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಕ್ಟ್ ಬಗ್ಗೆ ಹೇಳಿ ಸಾಕು. ಬೈಕ್ ನಲ್ಲಿ ಹೋಗೋಣ ಬಾ ಅಂತ ಕರೆದ, ನಾನು ಬರುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿದ. ಅದಕ್ಕೆ ನಾನು ಮದುವೆ ಆದ ಉದ್ದೇಶದಿಂದ ಅವನು ತಂದಿದ್ದ ಬೈಕ್ ನಲ್ಲಿ ಕೂರಿಸಿಕೊಂಡು ಶಾಮನೂರಿನಲ್ಲಿ ಅಣ್ಣನ ಮನೆಗೆ ಹೋದನು. ಅಣ್ಣನ ಹೆಂಡತಿಯ ಜೊತೆಯಲ್ಲಿ ಉಳಿದುಕೊಂಡು ಅವರ ಜೊತೆಯಲ್ಲೇ ಮಲಗಿಕೊಂಡನು. ವಿನಯ್ ಮತ್ತು ಅವರ ಅಣ್ಣ ಬೇರೆ ಬೇರೆ ಮಲಗಿಕೊಂಡರು. ನಂತರ ದಿನ ಬೆಳಿಗ್ಗೆ ನಾನು ಹಾಸ್ಟೆಲ್ಗೆ ಹೋಗಲು ಹೊರಟಿರುವಾಗ ನನ್ನ ಕರೆದುಕೊಂಡು ಬಂದಿರ್ತಾರೆ. ಅದನ್ನು ನನ್ನ ಮದುವೆ ಆದ ಉದ್ದೇಶದಿಂದ ಬೈಕ್ ನಲ್ಲಿ ಬರೀ ಕರ್ಕೊಂಡು ಹೋದ ಅಷ್ಟೇ, ಬೈಕಲ್ಲಿ ಅಷ್ಟೇ ಏನ್ರಿ? ಬೈಕಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋದ ಅಷ್ಟೇ. ತೊಗೊಳ್ಳಿ. Same. Heard the petitioner counsel and also the counsel appearing for the state. The factual aspects of the case of the prosecution is that this petitioner, following the victim to attend the college, and that on 22/11/2021, when she was returning after the college hours, he took her to the house of Annan Manege, house of his brother. And on the next day, she about to go to college. At that time, police came and took her to police station, and hence he has got the complaint. The police have registered the case against the petitioner for the offence 364A, 354 of IPC and section 8 and 12 of POCSO Act. The victim girl is also examined before the learned magistrate. The counsel appearing for the petitioner would submit that in the complaint only allegation is made that he took her in the motorcycle. Even invoke the offences under section 8 and 12 of the POCSO Act also. No ingredients are made out in the complaint, and in 164(5) statement also nothing is attributed against this petitioner. For contra, the counsel appearing for the state would submit that in the averments made in the complaint has been reiterated in the 164 statement also. I heard the respected counsel and also on perusal of material, particularly the complaint averments and also 164 statement. No prima facie material is collected, even in section 8 and 12 of POCSO Act. And also with regard to the other offences, only allegation is that he took her to the house of her brother, and hence it is a fit case to exercise the discretion in favor of the petitioner with conditions. 65 Sayyid Akbar Pasha, A1, 3, 4, 5, 6 of 370. ಏನು ಕೆಲಸ ಏನು A1 ಏನ್ ಮಾಡಿದ್ರಿ ಇದರಲ್ಲಿ? ರನ್ನಿಂಗ್ ಬ್ರಾತೆಲ್ಲ ಇಲ್ಲಿ ಯಾರೋ ಇವ್ರಿಲ್ವಾ? ಮಕ್ಕಳು ಯಾರು ಇಲ್ವಾ? ಮೈನರ್ ಯಾರು ಇಲ್ಲಲ್ಲ? ಹಾ, ಮತ್ತೆ ಆಕೆಗೆ ಎಷ್ಟು ವಿಕ್ಟಿಮ್? 50 years. ಹಾ, 439. ಯಾವಾಗಿಂದ ಇದಾರೆ ಕಸ್ಟಡಿಲಿ? 9/12/2021. ಬೇರೆ ಏನಾದ್ರು ಕೇಸಸ್ ಇದಾವ? ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಇದೆಯಾ? ಅರ್ಲಿಯರ್ ಏನಾದ್ರು ಸೇಮ್ ಇಂಡಲ್ಸ್ ಇನ್ ಸಿಮಿಲರ್ ಆಕ್ಟ್ಸ್? ಇಲ್ಲ. ನೋಡಿ, how the petitioner counsel and also the counsel appearing for the state. The allegation against this petitioner that this petitioner is running brothel. On credible confirmation, along with staff, conducted the raid. They seized an amount of ₹1,000, and also mobile, and also condoms, and also rescued a victim. And arrested this petitioner and others. Only this petitioner. ಇವರೆಲ್ಲ ಕಸ್ಟಮರ್ಸ್ ಎಲ್ಲ ಏನದು ಇರ್ಲಿಲ್ವಾ? ರಚಿಸಲ್ಪಟ್ಟ ವಿಕ್ಟಿಮ್ಸ್ ಇದ್ದಾರೆ. Apprehended this petitioner and there were 3 victims. Said brothel house, and case has been registered and now under investigation alla complete agilla. Now matter under investigation. The petitioner submits that false case has been registered against this petitioner and no any criminal antecedents against this petitioner, and this petitioner is in custody from 10/12/21 and almost investigation has been completed and no need of further custodial investigation. Per contra, the counsel appearing for the petitioner submits that on credible information only this petitioner was apprehended, but no customers were there, but only victims were there in the brothel house. Having heard the respective counsel and also on perusal of material available on record, particularly allegation against this petitioner that he is running brothel and there were 3 victims and only this petitioner is apprehended and no customers were there at that time and no any criminal antecedents against this petitioner, and this petitioner is in custody from 10/12 and hence there is no need of further custodial investigation and hence petitioner is entitled for bail with certain conditions. Prasanna Kumar P. Lakshmi ji, advocate for victim. Child. Marriage?
Married to one of the victim girl.
Accused. This petitioner. What is her age?
She is the case from
17 and a half.
The complaint is filed by a stranger stating that he is seeing the girl, she is around 17 pregnant.
Pregnant.
Pregnant she is 17. He presumes not there is age bar not and then files the complaint. On that basis, not the FIR comes to be registered as page number 10. Complaint will not be page number 13.
Complaint not by unknown person. It is by the CDPO.
CDPO, not the
CDPO. Yes. Next.
It's a complaint made.
ನಾಲ್ಕು ತಿಂಗಳ ಗರ್ಭಿಣಿಯಾಗಿರುತ್ತಾಳೆ, ಸೋನ್ಸೋ ಆಗಿದ್ದು ಗರ್ಭಿಣಿ ಅಂತ ದೃಢಪಟ್ಟಿರುತ್ತೆ. ಅಪ್ತಾಬ್ದ ಫಲಕ್ಕಿನ ಮದುವೆಯಾದ ಶ್ರೀಧರ್ ಸೋನ್ಸೋ ಒಳಪಡಿಸಿ ಸೋನ್ಸೋ. ನೆಕ್ಸ್ಟ್. ಆಮೇಲೆ ಆಲ್ಸೋ ಗೇವ್ ಬರ್ತ್. 19 ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಯು ಆರ್ ರಿಲೈಯಿಂಗ್ ಅಪಾನ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್.
Marriage not that leading not married life.
ಆಯ್ತು. ವಿಕ್ಟಿಮ್ ಗರ್ಲ್ ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನಾದ್ರು ಇದೆಯೇನ್ರಿ? ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ? ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಪ್ರೆಗ್ನೆಂಟ್ ಇದ್ದಾಳಲ್ಲ. ಆಯ್ತು, ಪ್ರೆಗ್ನೆಂಟ್ ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ವಿಕ್ಟಿಮ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರು. ಬಂದಿಲ್ವಾ? ಮತ್ತೆ ನೋಡಿ ತರ್ಸ್ಕೊಂಡು. HCCP is directed to secure the 164 statement of the victim. List this matter on 21st. 67 Vivek BR. 498, 323, 504, 506. Only those offenses. Senri. ಅಷ್ಟೇ ಅಲ್ಲ, 307 ಬೇರೆ ಏನಿಲ್ಲ. Third, the petitioner counsel and also the counsel of the state. The factual matters of the case of the prosecution is that the complainant in the complaint stated that her marriage was solemnized in 2014 and thereafter she has led the marital life with Meena Road accused husband along with this petitioner from 2015 to 20, and this petitioner came into house with the influence of alcohol every day, and also he is having relationship with 438 entry though. ಮತ್ತೆ ಮತ್ತೆ
It has been rejected on the ground that he is having an illicit relationship.
ಇದೆಯಲ್ಲ, ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್ಸ್ ಇದೆ, ಯಾಕೆ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಬರ್ತಾ ಇದ್ದ ಅಂತ. ಮತ್ತೆ
It is because the settlement for the mutual consent divorce has not happened.
ಅಂತಂದ್ರೆ 5-6 ವರ್ಷ ಲೈಫ್ ಲೀಡ್ ಮಾಡಿ ಆಮೇಲೆ ಮತ್ತೆ
ಬೆಂಗಳೂರಿಗೆ 2020 ಬರ್ತಾರೆ ಅವರು ಮಲೇಷಿಯಾದಿಂದ. ಅವಾಗ ಫೈಲ್ ಮಾಡಲ್ಲ ಕಂಪ್ಲೇಂಟ್,
ಯಾರು ಇಮಿಡಿಯೇಟ್ ಮ್ಯಾರೇಜ್ ನ ಕಳ್ಕೊಳಕ್ ಇಷ್ಟಪಡಲ್ಲ, ನೋಡ್ತಾರೆ, ಕಾದ್ ನೋಡ್ತಾರೆ, ಎಲ್ಲ ಮಾಡ್ತಾರೆ. ನೀವು ನಾಟ್ ಎ ಕೇಸ್ ಫಾರ್ 438.
ಮಾಡಲ್ಲ. ಇಲ್ಲಿ ಬಂದರೂ ಕೂಡ ಎಷ್ಟೋ ತಿಂಗಳು ಆದ್ಮೇಲೆ ಫೈಲ್ ಮಾಡ್ತಾರೆ, ಯಾಕಂದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ಮೂವ್ ಕೊಡ್ತೀವಿ, ಅದನ್ನ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂತ ಹಸ್ಬೆಂಡ್ ಹೇಳ್ತಾರೆ. ಹಂಬಲ್ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್.
ಆಯ್ತು, ಪೊಲೀಸ್ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ಲಿ, ನೋಡಿ whether he is having illicit relationship with other woman. Let the police procure the records, investigate the matter.
ಮಲೇಷಿಯಾದಲ್ಲಿ ಆಗಿತ್ತು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಎಲ್ಲ ಅಲ್ಲಿ ಹೇಳ್ತಿರೋದು. jurisdiction before the women police station Shivaji Nagar the allegations ಮಾಡಿರೋದು. Two page numbers I may please point out. Page 48 of my lord of please to take. This is the legal notice that she had got issued to her advocate. Page 48 ನಲ್ಲಿ I just want to point out one inconsistency that shows the malified intent behind this complaint. I read bottommost page 48 para R my lords. My lords have please view the addressee number 1 referring to the petition my lords.
Legal notice
legal notice issued by advocate of the wife complaint. Reading lords, view the addressee number 1.
ಆಯ್ತು, ನೋಟಿಸ್ ಒಂದು 25 ಪೇಜ್ ಇದೆ.
ಅದಕ್ಕೆ ನಾನು only 2 lines I am not reading out. Okay, just one line ಅಷ್ಟೇ. Please see this. 48 minutes. W at the bottom. My client has tried to reconcile with you regularly. This is after return to India. Please look at what she says in her complaint. Type copy at page number 23, my lords. Please take page 23. What she says in her complaint. Second para I read. Tarini, who is the petitioner, my lords, the husband, then came back to India and we tried to reconcile, but I tried to move ahead. She says in her complaint before the police that she tried to move ahead only to make out a case here. Legal notice, compensation, case she says, I tried to reconcile with you. This is the first, my lord. Second, if my lords have again page 49 of the legal notice, there is a lot of inconsistency. 49 and first para I read. Now she is on crossroads and totally dependent on her old age parent for her financial needs. Only compensation she makes out a case of financial hardship. Please come to the complaint that she files. She says, back to page 23, my lords, last but one para, my father is a retired government worker and mother is a housewife. I am the sole breadwinner of my family. Illi helbekadre he is torturing me. I am the sole breadwinner anta helodu. When she is building up a case for compensation.
Allegation and complaint alli idೆಯೇ ಇಲ್ಲ. Illicit relationship ಬಗ್ಗೆ.
Illicit relationship ಅನ್ನೋದು it's a completely made up case. Going by the facts, my lord, these were two colleagues, man and woman, who came to stay with petitioner and the complainant. There was a couple who was staying with them. It is not that he has brought in some other woman and attempted an illicit relationship. Also, my lord,
any specific allegation against that lady? Complaint ಅಲ್ಲಿ ಇದ್ದಾಗ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ, specific allegation ಇಲ್ಲ.
23 ಅಲ್ಲೇ specific word ಇದೆ, ಅದು para number 3 ಅಲ್ಲೇ. Not only ruined my prospectus of continuing his marriage with his adultery and alcoholic abuse, but with whom she is having anandana idea. ಒಂದು ನಿಮಿಷ ಇರ್ರಿ, ತಾಳ್ಮೆ ಇಟ್ಕೋಬೇಕು. ಮತ್ತೆ I am asking some questions to him, whether the complainant specified the name of with whom he is having illicit relationship with her. ಅಂತ ಅದೇನಿಲ್ಲಲ್ಲ, only general omnibus allegation. Tole madam. ಯಂಗ್ಸ್ಟರ್ಸ್ ಸ್ವಲ್ಪ ತಾಳ್ಮೆನೇ ಇರಲ್ಲ. ಎಲ್ಲ ಒಂದು ನ್ಯಾಷನಲ್ ಸ್ಕೂಲ್ ಅಲ್ಲ ಎಲ್ಲ ಓದ್ಕೊ ಬಂದ್ಬಿಟ್ಟಿರ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಂಗ್ಲಿಷ್ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ ಇದೇನೆ ವಾಟ್ ವಿ ಆರ್ ಅಬ್ಸರ್ವಿಂಗ್. ಏನ್ ಹೆಸರು ನಿಮ್ದು? ವರುಣ. ವಿವೇಕ್ ಅಂದ್ರೆ ಯಾರು? ಅದೇನೆ. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಈಗ ಏನ್ ಯಂಗ್ಸ್ಟರ್ಸ್ ವಾಟ್ ವಿ ಆರ್ ಅಬ್ಸರ್ವಿಂಗ್ ದಟ್ ಪೇಷನ್ಸ್ ಇರಲ್ಲ. When the court has asked the questions to the PP, alva, heard the petitioner counsel and also the counsel appearing for the state. ಹೇಳಿದೀನ ಏನ್ ಹೇಳಿದೀನ? ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದಲ್ಲ, ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದೆ. ರಿಲೇಶನ್ಶಿಪ್ ವಿತ್ ಅದರ್ ವುಮನ್. ಇಲ್ಲಿದೆಯಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ, FIR ಅಲ್ಲಿ ಬಂತದ್. ಮತ್ತೆ ತಡವಾಗಿ ಮನೆಗೆ ಬಂದು ರೋಸ್ಲಿನಾ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಹೆಸರಲ್ಲಿ ಮತ್ತೆ ಇದು FIR ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, ಪೇಜ್ ನಂಬರ್ 18 ಅಲ್ಲಿ. Specific name is also mentioned with whom he is having. ಇದೆ ನೋಡಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದೆ ಅಲ್ರಿ. ಇಂಗ್ಲಿಷ್ ಅಲ್ಲೇ ಇದೆ ನೋಡಿ, ಫಸ್ಟ್ ಅಲ್ಲೇನೆ. ಟ್ರೈನಿ threw me out of the house after bringing his colleague Roslina Binti Mohammed to stay in our house. I came back to India under a lot of ಅಲ್ಲ ಇದಾಗಿರೋದಲ್ಲ ಫಾರಿನ್ ಅಲ್ಲಿ ಇದ್ದಾಗ. Came back to India under a lot of. Heard the petitioner counsel and also the counsel of next ಏನಾಯ್ತಲ್ಲ ಸಂಬಂಧ with one colleague Roslina Binti Mohammed, and he used to bring her to his house and subjected her for both physically and mental cruelty, and driven out her from the matrimonial home, and hence he came to India. When he is staying in the apartment, and he had joined her and continued the illicit relationship with other woman and causing like threat. Counsel appearing for the petitioner would submit that a false allegation is made that this petitioner is having illicit relationship with pointed out the specific name in India with whom he is continuing the illicit relationship, and only general omnibus allegation is made. The counsel also brought to the notice of this court the notice issued by the complainant, wherein also she has stated with regards to reconciling with the petitioner, and also no specific allegation is made, and the trial court has rejected the bail petition only on the ground that he is having illicit relationship with other women. For contact, the counsel appearing for the state would submit that in the complaint specific name is mentioned, but no name is mentioned with regard to continuing illicit relationship in India. The matter is under investigation, and this petition is filed under section 438, and the presence of this petitioner is required. Having heard the petitioner counsel and also the counsel appearing for the state, and also taking into note of the allegations made in the complaint, physical and mental cruelty, apart from that assault and threat abuse or in language, and apart from that in the complaint only specific allegation is made that he was having illicit relationship with one colleague and he used to bring her. But the complaint is specific. In the complaint specifically mentioned that when she came back to India, when she is staying in a apartment, and this petitioner also joined her. But allegation is made that continued his illicit relationship, but not mentioned the name of the person with whom she is having illicit relationship. Only general allegations is made. In such being the factual aspects of the case, it is a fit case to exercise the provisions 438 of CRPC with conditions. Jagan Babu.
For the petitioners, your lordship,
Counsel.
I appeal for the petitioner, Your Lordship.
Yes, counsel, I am able to hear you. Address your argument.
The offense under section 370 IPC and section 75 and 79 of Juvenile Justice Act. The allegation is the petitioner had engaged a child labor in his furniture shop. A raid was conducted and thereafter a FIR was registered. And thereafter charge sheet was filed for the said offense, Your Lordship, I kindly appreciate. In the entire
child labor appointment. I thought heard the petitioner counsel and also the counsel appearing to the state. The case of the prosecution that this petitioner engaged the services of minor children in his shop. But hence invoked the offense on section of IPC and section 75-79 of Juvenile Justice Act. Counsel appearing to the petitioner. The police have investigated the matter and filed the charge sheet. The petitioner counsel in this argument vehemently contend that offences are not punishable with death or imprisonment for life, and only allegation that minor children are employed in the shop belongs to this petitioner. And he had never engaged in any child labor in the alleged shop. Hence, he may be enlarged on bail. For contrary, the counsel appearing for the state will submit that the material discloses that when the raid was conducted, the petitioner had a furniture shop wherein CW 126 are the children below the age of 18. CW 11 to 14 were the part of the raid, and and they have found the 4 children working in the furniture shop. I heard the petitioner counsel and also the counsel appearing for the state and also taking into note of the gravity of the offense and allegations made against this petitioner. And also allegation is that he is having furniture shops wherein he is employed 4 children in the shop, and the same has been denied by this petitioner, and hence whether he had engaged the minor children for employment has to be tested in trial, and hence petitioner has made out the ground to report the date of CRPC to enlarge him on bail allowed with conditions. 69 Sidmalappa ಏನ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ 8 ಎಷ್ಟು ಈಗ ಪಾಸ್ ಓವರ್ ಆಯ್ತು 70 ಅರ್ಜುನ್ 71 ಶರಣ್ ಕೆ Page number 29. Yes, counsel. ಯಾವಾಗಲೂ ಒಂದ್ಸರಿ ಬಂದಿತ್ತಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ವಿ ರೆಡ್ ಅಲ್ವಾ? ಪೇಜ್ ನಂಬರ್ 20 ನಾನು ಅಂಡರ್ಲೈನ್ ಎಲ್ಲ ಮಾಡಿದ್ದೀನಿ ಹೇಳಿ. ಆಯ್ತೇನು ವೈ ಇಟ್ ವಾಸ್ ಅರ್ಜೆಂಟ್ ಲಾಸ್ಟ್ ಟೈಮ್? ಕನೆಕ್ಟಿವಿಟಿ ಪ್ರಾಬ್ಲಮ್. ಆಯ್ತು ಹೇಳಿ. ಏನೋ ಕುಡ್ದೇನೋ ಗಲಾಟೆ ಮಾಡ್ಕೊಂಡು ಏನೋ ಮಾಡಿರ ಅದ ರಾಗಿ ಇಟ್ಟು ಅದೇ ಇಬ್ರು ಕೋಳಿ ಮಾಂಸದ ಊಟ ಹಾಕ್ಲಿಲ್ಲ, ಅದಕ್ಕೇನೋ ಮುದ್ದೆ ಮಾಡಕ್ ಅನ್ನ ರಾಗಿ ಹಿಟ್ಟು ಇರ್ಲಿಲ್ಲ ಅಂತಲೇನು. ರವಿಯ ತಲೆಗೆ ಅದೇ ಕಾಫಿ ದೊಣ್ಣೆಯಿಂದ ಹೊಡೆದಾಗ ಸ್ಥಳದಲ್ಲಿ ರವಿಯ ತಲೆ ಕುಸಿದು ಬಿದ್ದು ಸಾಕ್ಷಿ CW 2 and 3 tried to provide him the water. By that time he already passed away. ಆಯ್ತು ಹೇಳಿ.
ಈಗ ವಾಟರ್ CW2 ಮತ್ತೆ 3 ನೀರು ಕುಡಿಸಿದಾಗ ಕೂಗ್ತಾ ಇದ್ದ, ಅವನು ಬದುಕಿದ್ದ, ಏನು ಒಂದು ಮಾತಾಡಿಲ್ಲ, ಯಾರು ಮಾಡಿದ್ದಾರೆ ಏನು ಹೇಳಿ. CW2
whether they have witnessed the incident or not,
but they are made it as a witness. Only CW2 is a witness.
ರಾತ್ರಿ ಎಲ್ಲ ಗಲಾಟೆ ಮಾಡ್ಕೊತಿದ್ರು ಕುಡಿದು. ಬೆಳಗ್ಗೆ 3:45 ಗಂಟೆನಲ್ಲಿ ಇಬ್ರು ಗಲಾಟೆ ಮಾಡ್ತಿದ್ದಾಗ ಸಾಕ್ಷಿ 2 ಹೋಗಿ ನೋಡಿದಾಗ ಆರೋಪಿ ಒಂದು ಕಾಫಿ ದೊಣ್ಣೆಯಿಂದ ಪುತ್ರ ರವಿಗೆ ಬಲವಾಗಿ ಮಾರಣಾಂತಿಕವಾಗಿ ಹಲ್ಲೆ ಮಾಡಿ ಹೊಡೆಯುತ್ತಿದ್ದಾಗ ಸಾಕ್ಷಿ 2 ಯಾಕೆ ಹೊಡೆಯುತ್ತೀಯಾ ಎಂದು ಕೇಳಿದಾಗ ಆರೋಪಿಯು ಈ ಬೋಳಿ ಮಗ ರಾಗಿ ಇಟ್ಟು ತಂದಿಲ್ಲ ಎಂದು ನನ್ನೊಂದಿಗೆ ಜಗಳ ಮಾಡಿ ಕೋಳಿ ಮಾಂಸದ ಊಟವನ್ನು ಒಬ್ಬನೇ ಮಾಡಿಕೊಂಡು ನನಗೆ ಊಟ ಕೊಡದೆ ಲೈನ್ ಒಳಗಡೆ ಅಂತ ರೀಸನ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟ ಅಂತ ಹೇಳ್ತಾನೆ. ಮೇಡ್ ಹಿಮ್ ಟು ಸ್ಲೀಪ್ ಔಟ್ ಸೈಡ್. ಕಾರ್ಡ್ ಜಾತಿ ಅವನು ಮಾಜಾರ್ ವಿಟ್ನೆಸ್ ಗೊತ್ತಿರ್ಬೇಕಲ್ಲ, ಅದು ಕಾಫಿ ಗಿಡುವ ಅಥವಾ ಏನು. ಇಸ್ ಇಟ್ ಎ ಗ್ರೌಂಡ್ ಫಾರ್ ಬೇಲ್? Fracture of skull. Fracture of skull right side. There was fracture of bridge of the nose. Right ear bleeding present. Right frontal parietal bone fracture. Sumar injuries ideyalri. Not one injury. Cause of death is due to head injury. ಆಯ್ತು, ಇಬ್ರು ಕುಡ್ದವ್ರು ಏನ್ ಮಾಡೋ, ಕುಡ್ದ ಜೀವ ತೆಗಿಬೇಕು ಅಂತಿಲ್ವಲ್ಲ. ಏನ್ರಿ ಹೇಳಿ. ಲೇಬರ್ ಆದ್ರೂ ಅಷ್ಟೇ, ಯಾರಾದ್ರೂ ಅಷ್ಟೇ, ಜೀವ ತಗೊಂಡ್ಮೇಲೆ ಜೀವನ ಒಂದ್ ಜೀವ ತೆಗೆದ್ಮೇಲೆ ಆಯ್ತು. ಮರ್ಡರ್ ಕೇಸಲ್ಲಿ ಏನ್ ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ನೋಡ್ತಿರ್ರಿ? ಏನಾರು ಡಕಾಯಿತಿ ಅಥವಾ ಏನಾರು ರಾಬರಿ ಇಂಥವಕ್ಕೆಲ್ಲ ಆದ್ರೆ ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ನೋಡ್ಬೋದು ಅಲ್ವಾ? ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಏನಿರುತ್ತೆ ಹೇಳ್ರಿ. ಬ್ಲಡ್ ಸ್ಟೈನ್ ಕ್ಲಾತ್ಸ್ ಆಲ್ಸೋ ಸೀಸ್ಡ್. FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಏನಿದೆ ಇದೆಯಾ, ಕನ್ಫರ್ಮ್ ಆಗಿದೆಯಾ? ರಿಪೋರ್ಟ್ ನೋಡೋಣ, FSL ರಿಪೋರ್ಟ್ ಬರಲಿ ಆಮೇಲೆ ನೋಡಿ. Heard the petitioner, counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 27/2/2021, both the petitioner as well as the deceased quarreling each other at around 8 p.m. Both of them were under the influence of alcohol. And CW2 went and pacified both of them. On the very same day, at around 3:45 a.m. again, both of them were quarreling each other. And when the CW2 went and was questioned, the petitioner scolded and replied that the deceased made him to live outside the line and not provided the food. And he alone ate the non-vegetarian food. That motive, he inflicted the injury with the coffee plant stick. As a result, he has sustained injuries and succumbed to the injuries. The counsel appearing for the petitioner would submit that the very complaint and material collected by the prosecution clearly discloses that both of them were under the influence of alcohol. Apart from that, the statement of CW2 witnessing the incident at the early morning at 3:45 a.m. cannot be believed. And the prosecution mainly relying upon the statement of CW2, who is alleged eyewitness. And there was no any motive to commit the murder, and them are workers working in the coffee estate. Investigation already completed. No need of custodial trial. For contrary, the counsel appearing for the state would submit that the incident is witnessed by the CW2. And CW2 also statement is clear that in the early hours also at around 8 p.m. both of them were quarreling each other and he pacified. And again at 3:45 a.m. also the quarrel was continued and he noticed inflicting injury with coffee plant stick, that on the vital part on the head. And cause of death is also on account of injury sustained by him on his head. And hence there is a prima facie case. Having heard the petitioner, counsel and also the counsel appearing for the state also says would submits that the bloodstained cloth of the accused also sent for FSL and FSL report is awaited. Having heard the respective counsel and also on perusal of material against this petitioner, specific allegation is made that he inflicted injury with coffee plant stick, that too on the vital part. and they said the incident is witnessed by CW2. Even though CW2, when he questioned, he replied that he is having motive, that he has not provided the food and made him to sleep whole night outside the line, and hence he inflicted the injury. The cause of death also is specific, that he had sustained a head injury and there were fractures. And when such being the factual aspects, and apart from that, the bloodstained cloth of accused also seized and the same was sent to the FSL. The FSL report is awaited. When there is a prima facie case, it is not a fit case to exercise the discretion to enlarge the petitioner. You have the discussions made also. The petition is rejected. However, liberty is given to approach this court after receipt of the FSL report. If anything is in favor of the petitioner, bloodstains illa andre barbodu. Bloodstains iddu firm andre illa. Apart from direct evidence, circumstantial evidence also. Sridhara. Yes, counsel.
Earlier, the petitioner approached the criminal petition number 6329 of 2019. This was on 4th November 2019, page number 27. Another counsel for the petition, after arguing the matter for some time, seek permission to withdraw the liberty to
After the examination of material witnesses.
In this matter, they already the CW 1 to 5 have been examined as PW 1 to 5. And there are hostile.
All are hostile.
All are hostile. They accept the complaint CW 1.
CW1 ಇನ್ನು ವಿಚಾರಣೆ ಆಗಿಲ್ಲ.
ಆಗಿದೆ. Cross examination ಆಗಿದೆ.
ಸಪೋರ್ಟ್ ಮಾಡಿದಾರಾ ಅವರು?
Support ಅಂತಲ್ಲ, she is not the eyewitness. She is
ಆಯ್ತು, ಸಪೋರ್ಟ್ ಮಾಡಿದಾರಾ?
ಕೊಲೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಒಂದು ವರ್ಡ್ ಹೇಳ್ತಾರೆ. There is no motive or intention. Because ಏನ್ ರೀಸನ್ ಅಂತ ಹೇಳಿದ್ರೆ, ಅವರು ಇಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ರು. ಅಲ್ಲಿ ಅವರು ಲಾಯರು ಸಾಲ ಮಾಡ್ಕೊಂಡಿದ್ದನ್ನ ತಮ್ಮ ಬೇರೆಯವರು ತಿಳಿಸ್ತಾ ಅಂತ ಹೇಳಿ ಗಲಾಟೆ ಆಯ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. But entire case,
according to you, material witnesses ಅಂತ ಯಾರು?
circumstances.
Because there is an observation that material witnesses.
Only circumstances ಅವ್ರು ಹೇಳ್ತಕ್ಕಂಥದ್ದು ಆ ಒಂದು ಕಾರಣಕ್ಕಾಗಿ ನಡೆದಿದೆ.
Case rest upon the circumstantial evidence.
Witnesses ಇರ್ತಕ್ಕಂಥದ್ದು only Mahadar witness, inquest Mahadar. Inquest Mahadar ಸಹ.
You are not answering to my question. Case rest upon the circumstantial evidence ಅಥವಾ direct evidence ಇದೆಯಾ? Circumstantial evidence. ಏನ್ರಿ? Circumstantial evidence. As for the case of the prosecution, eyewitnesses ಇದಾರ? ಮತ್ತೆ ನಾವು ನೋಡ್ರಿ ಸರ್ಕಮ್ಸ್ಟೆನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್ ಅಂತಾರೆ. ಐವಿಟ್ನೆಸಸ್ ಇಲ್ವಾ? ಆಯ್ತು, ಇನ್ನೇನ್ ಮಾಡೋದು? ನಾವೇ ಚಾರ್ಜ್ ಶೀಟ್ ಹೋಗ್ಬಿಡೋಣ. ನೀವುಗಳೆಲ್ಲ ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡದವ್ರು ಏನ್ ಮಾಡೋದು? ನಾವು ನೋಡಿ ದಿನಕ್ಕೆ 100 ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ. ಇವತ್ತು 100 ಇದೆ, ಅರ್ಧ ದಿವಸ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? You should assist the court. Where is the charge sheet?
Charge sheet is page number 28.
28.
TW1 paper 31 ಅಲ್ಲಿ ಲಿಸ್ಟ್ witnesses ಮತ್ತು ಅವರ description.
ಯಾರು ಇಬ್ರು ಸರಿಯಾಗಿದ್ರು. ಕಂಪ್ಲೇಂಟ್ ವಿಟ್ನೆಸ್ ಫಿರ್ಯಾದುದಾರರಾಗಿದ್ದು ಕೃತ್ಯದ ಬಗ್ಗೆ ಸ್ಥಳ ತೋರಿಸಿ ಮಹಾಜರ್ಗೆ ಸಹಿ ಮಾಡಿರೋ ಬಗ್ಗೆ ನುಡಿಯುತ್ತಾರೆ ಅಂತಿದೆ. ಎಲ್ಲಿದೆ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿಗಳು ಅಂತ ಯಾರಿದ್ದಾರೆ? ಅವ್ರು ಮೃತನ ಹಿರಿಯ ಹೆಂಡತಿ ಆಗಿದ್ದು ತಾವು ನೀಡಿರೋ ಹೇಳಿಕೆ ನೃತ್ಯ ನುಡಿಯುತ್ತಾರೆ. ತಾಯಿ ಆಗಿದ್ದು ತಾವು ನೀಡಿರೋ ಹೇಳಿಕೆ ನುಡಿಯುತ್ತಾರೆ. ಎಲ್ಲಿದೆ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿ? ಆಯ್ತು, ಸರ್ಕಮ್ಸ್ಟೆನ್ಷಿಯಲ್ ಎವಿಡೆನ್ಸ್ ಏನ್ ಹೋಗ್ಲಿ? ವಾಟ್ ಮೆಟೀರಿಯಲ್ ಯು ಕಲೆಕ್ಟೆಡ್? ಬ್ಲಡ್ ಸ್ಟೈನ್ ಕ್ಲಾತ್ ಆಫ್ ದಿ ಅಕ್ಯೂಸ್ಡ್ ಕಲೆಕ್ಟ್ ಮಾಡಿ FSL ರಿಪೋರ್ಟ್ ಏನಾರು ಇದೆಯಾ? ಮ್ಯಾನರ್ ಆಫ್ ಮರ್ಡರ್ ಏನು? ಒಂದೇ ನಿಮಿಷ, ನಾನೇ ಓದ್ಬಿಡ್ತೀನಿ. ಕಾಲಮ್ ನಂಬರ್ 17, ಪೇಜ್ ನಂಬರ್ 36. ಅಣ್ಣ ತಮ್ಮ ಆಯ್ತು. ಏನು ಏನು seized at the instance of witnesses. ಹೌದಾ? ಆ ಮಾಜರ್ ವಿಟ್ನೆಸಸ್ ನ ವಿಚಾರಣೆ ಆಗಿದೆಯಾ? ಹಾಕಿದಾರಲ್ಲ ಇಲ್ಲ ಡಿಪೋಸಿಷನ್ಸ್ ಹಾಕಿದಾರೆ ನೋಡಿ, ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ವಾ ನಿಮ್ಗೆ? ಫ್ರಮ್ ಪೇಜ್ ನಂಬರ್ 92 ಏನೋ ಇದೆ ನೋಡಿ ಇಲ್ಲಿ PW5 ಪಿಟಿಷನ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋ ಕೊಟ್ಟಿದಾರ ಇಲ್ಲ PW1 ಫ್ರಮ್ 98 to 139. ಮಾಜರ್ ವಿಟ್ನೆಸ್ ಎಕ್ಸಾಮಿನ್ ಆಗಿದಾರೇನ್ರಿ? ರಿಕವರಿ ಆಗಿದಾರ? ರಿಕವರಿ ಆಫ್ ದಿ wherein the wooden club also been sent for forensic examination. That also discloses stains ಇದೆ. ಆಯ್ತು, ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಆಗಿದ್ಯಾ? ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಆಗಿದ್ಯಾ? ಮತ್ತೆ ಏನ್ರಿ ಅದಾಯ್ತು. ಈಗ FSL ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಬ್ಲಡ್ ಸ್ಟೈನ್ಸ್. ಏನು ಅಕ್ಯೂಸ್ ಏನಾದ್ರು ಬ್ಲಡ್ ಸ್ಟೈನ್ ಕ್ಲಾತ್ ಏನಾದ್ರು ಸೀಸ್ ಆಗಿದೆಯಾ? ಓನ್ಲಿ ದಿ ವೆಪನ್ which was used, where it was recovered? ಇತ್ಲಲ್ಲಿ ನಿಮ್ಮವನೇ ಕರ್ಕೊಂಡೋಗಿ ತೋರಿಸಿರೋದಾ? ಆಯ್ತು, ಅವ್ರನ್ನ FSL ನವ್ರು ಬರ್ಲಿ ವಿಚಾರಣೆ ಆಗ್ಲಿ, ಆಮೇಲೆ ನೋಡಿ. What is the petitioner counsel and also the counsel appealing for the state?
Engage the service of private counsel. Thereafter, they filed the memorandum before the director of prosecution to appoint the special people because say drag the matter.
ಆಯ್ತು, ಏನ್ ಮಾಡೋದು? ಎವಿಡೆನ್ಸ್ ಹಾಕ್ಬೇಕಲ್ಲ. ಏನಾಯ್ತು ಮೇಡಮ್? Petitioner counsel and also the counsel appearing for the state. The fact and matters of the case of the prosecution that this petitioner is the brother of the victim and he committed the murder by inflicting the injury with a wooden stick, and hence case has been registered and invoked section 302. The counsel appearing for the petitioner would submit that the petitioner earlier approached this court 6329 of 2019, wherein this court given liberty to the petitioner to approach the trial court. Liberty to approach trial court for bail and bail on any circumstances after examination of the liberty to the petitioners to approach the trial court for grant of bail. On any change circumstances after examination of the material witnesses. ಅಲ್ಲೇ ಕೇಳಬೇಕು ಅಂತಿದೆ, ನಾಟ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್. ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ? ಆಯ್ತು, ಏನಾಯ್ತು ಮೇಡಮ್?
Examination of the
material witnesses and the petitioner has approached the trial court and the same has been rejected, and hence before this court the counsel appearing for the petitioner would submit that already PW 1 to 5 have been examined and those are the material witnesses and they have not supported the case of the prosecution. Only complainant ವಿಚಾರಣೆ ಆಗಿಲ್ವಾ? And PW3 also examined and PW3 only supported and other witnesses have not supported. ಹೌದಾ? ಕರೆಕ್ಟಾ? And the PW3 is also not an eyewitness. The counsel that also examined regarding recovery of the gun stick which was used for committing the murder. No material is forthcoming against this petition and hence this petition may be enlarged on bail. For content, the counsel appearing for the state would submit that the weapon used for committing the offense was seized and the same was contains the blood stains and the same was sent to the FSL and the FSL report is also the blood stains of the deceased, and when the recovery is made at the instance of this petitioner, the examination of the FSL witness is also necessary. Having heard the respective counsel and also on perusal of material, no doubt the total 5 witnesses are examined. Out of that, PW3 is examined and the PW3 is supported the case of the prosecution and other major witnesses have not supported the case of the prosecution. However, yet to examine the FSL expert witness evidence and the recovery, whether recovery of the weapon which was used for committing the offense contains material, and the said witness is also a material witnesses, and hence unless the material witness, that is FSL expert, is not examined, this stage cannot consider the case of the petitioner for granting bail. In view of the discussions made up, I pass the following order. Earlier the matter pending irodu Srinagarpatna. petition is rejected. However, trial court is directed to examine the material witnesses as early as possible.
Yes, my lord. My lord, the petitioner is accused number 1, my lord. The deceased himself, my lord. Yes, my lord. Deceased himself is first informant, my lord. The complaint has been filed against, he has made allegations against unknown persons.
Against unknown persons?
Yes, my lord. Your lordship will find complaint on page number 13, my lord. And according to him, for the reason for his murder is that he is an RTI activist. And he had made
activist.
Yes, ma'am. He had made certain allegations regarding some illegalities committed regarding Gomal and other things. Here, according to them, those might have attempted on him. The assault has taken place on 15/7/2021.
15/7/2021.
Yes, ma'am. He died on 18/7/2021.
18/7.
Yes, ma'am. The accused is arrested on 10/7/2021. On 19/7/2021.
19/7.
Yes,
after the death.
Yes, so only thereafter, my lord, the motive and other things starts. My lord, your lordship will find the paragraph number 17 on page number 49, my lord. Case is
number 49.
Yes, 49, my lord. Case is based on circumstantial evidence, my lord. Admittedly, I was not on the scene of offense. According to case of prosecution, my lord, it is accused number 4, 5, 7 to 9 assaulted the deceased, my lord.
4, 5?
4, 5, 7 to 9. And according to my lord, according to case of prosecution, accused number 1, 2, 3, and accused number 6 conspired, and at our instance,
conspired.
Conspired, and the murder has been committed, my lord. And I have produced, my lord, the order passed by the learned district judge in respect granting bail to accused number 2, 3, and 6.
3 and 6.
That is criminal misdemeanor 776/21. And
next.
And accused number 9 also, my lord, has been granted bail in 8/45 for 2021. So in this background, your lordship may kindly see the allegations made against the petitioner, my lord.
Conspiracy ಬಗ್ಗೆ ಏನಾರು ಇದು ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಏನಾರು ಇದೆಯಾ?
ಇಲ್ಲ
date of the incident between this petitioner and also the other accused person?
Yes, I have
because
produced.
he is not in the scene of occurrence.
No, he was charge sheet I have produced, my lord.
ಈಗ ಕಾನ್ಸ್ಪಿರಸಿ ಪ್ರೂವ್ ಮಾಡಕ್ಕೆ ಏನ್ ಮೆಟೀರಿಯಲ್? prima facie material. But this man is not at the picture. ಹೌದಾ? Details illa. Then what are the incident CCTV footage avnilla bidi adu upyog illa nimge. Next, circumstantial evidence ಅಲ್ಲಿ ನಾನು ಕೇಳ್ತಾ ಇರೋದು ಏನಾದ್ರು ಈಗ ಇವನ್ ಕಾನ್ಸ್ಪೈರ್ಡ್ ವಿತ್ ಅದರ್ ಅಕ್ಯೂಸ್ಡ್ ಅಂದ್ರೆ ಅವರು ಅವತ್ತಿನ ದಿವಸ ಏನಾದ್ರು ಫೋನ್ ಕಾಲ್ಸ್ ಡೀಟೇಲ್ಸ್ ಆ ತರದ್ ಏನಿಲ್ಲ, ಮತ್ತೇನಿದೆ ಪ್ರೇಮ ಏನಿಲ್ಲ ತೋಡಿ. Or the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that the informant who had sustained the injuries given the information, and based on his information, case has been registered against unknown persons. And committing the murder, the victim is a RTI activist. And incident was taken place on 15/7/2021, and subsequent to the injuries, the injured succumbed to the injuries on 18/7/2021. The petitioner was apprehended on 19/7/2021, and thereafter he is in custody. The case of the prosecution also that accused number 4, 5, 7 to 9 have assaulted the victim, and accused number 1, 2, 3 have conspired each other in committing the murder. And the case is rest upon the circumstantial evidence. And the investigation also completed and charge sheet is filed. The counsel appearing for the petitioner would submit that the first instance case has been registered against unknown persons and the information of the deceased. And the very case of the prosecution that this petitioner conspired with other accused persons, that is A 1 to 3, accused number 2 and 3, and the accused number 4, 5, 7 to 9 have assaulted. In order to connect this petitioner, no material is collected by the IO, and already accused number 2, 3, 6, and 9 have been granted bail. And this petitioner is also entitled for bail since he was not at the spot, and only conspiracy has to be proved by examining the circumstantial witness. The counsel appearing to the state submits that petitioner conspired with accused number 2 and 3 and availed the services of accused number 4, 5, eliminating the deceased. And there are sufficient material against this petitioner. Having heard the petitioner counsel and also the counsel appearing for the state.
CCTV footage. Presence of accused was elicited. So they also the presence of accused.
But the incident ನಡೆದಿದ್ದು.
The witnesses who have seen the accused, other accused leaving the place, your lordship will find on page number 129, charge sheet have produced.
Charge sheet only I am verifying.
Yes, sir.
Place of incident, but CCTV footage irodilri, CCTV footage where this petitioner was present. Conspiring jaga elli idu according to prosecution.
Coourt finance hatra nintiದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ sir.
Coourt finance.
And he has paid amount, he has deposited the amount also. That also they have collected. He had gone to deposit some amount, other amount, not this some.
A1 deposited the amount in the Coourt finance.
In respect of the loan taken by his relative, not in connection with this case.
ಅದು ಯಾವತ್ತು ರೀ ಇದು CCTV ಕವರೇಜ್ ಇರೋದು ಯಾವತ್ತಿನ ದಿವಸ? Incident on 15/7. Coourt finance in the place of incident go ಎಷ್ಟು ದೂರ?
Kindly turn to
Anyhow, that is a matter of trial. Not at this spot. ಏನಾಯ್ತು ಮೇಡಮ್? Petitioner counsel and also the reasons ಬಂದಿಲ್ಲಲ್ಲ? Final reason. Having heard the petitioner counsel and also the counsel appearing for the state and also looking into the material available on record, this petitioner was not present at the spot. However, the counsel appearing for the state submits that CCTV footage is recovered and the presence of this petitioner was found near along with the assailants near the. ಯಾರ ಜೊತೆ ಇದ್ರಿ ಮತ್ತೆ?
ಇಲ್ಲಿ ಯಾರು ಇಲ್ಲಿ ಒಬ್ಬನೇ ಸರ್. your lordship may kindly return to page number 140 and 141. ಒಬ್ಬರೇ ಇದ್ದಾರೆ. come to yes 140 ಇವರು query ಹಾಕಿದ್ದಾರೆ.
ಹಾಗೆ ಹೇಳ್ತಾರೆ ಇವರು ನೋಡ್ರಿ ಈಗ ಹೇಳ್ತೀರಿ.
ಒಬ್ರು ಇಲ್ಲ ಸರ್, he was alone. Coourt finance ಯಾರು ಇರಲಿಲ್ಲ.
140
and 141 is the query of the IO and reply given by Coourt finance on 141, my lord.
That is with regard to the reply. Amount ಏನು ಕಟ್ಟಿದ್ರ ಬಗ್ಗೆ ಇದೆ.
ಮಾಡಿದ್ದು yes my lord.
Charge sheet material ಎಲ್ಲಿದೆ ರೀ? He was present along with other assailants ಅಂತ. Other assailants ಜೊತೆ ಅವಾಗ ಇದ್ದ ಅವನು ಅವತ್ತಿನ ದಿವಸ ಅಂತ ತೋರಿಸಿ. ಜಾಗದಲ್ಲಿ ಬೇಡ ರೀ, ಮುತ್ತೂಟ್ ಫೈನಾನ್ಸ್ ಹತ್ರಲ್ಲೂ ಇವನು ಇದ್ದ along with assailants ಅಂತ ತೋರ್ಸಕ್ ಏನಿದೆ? ಏನ್ ಮಾಜರ್? ಮಾಜರ್ ಇದೆ, ಬಟ್ ವೆದರ್ he was along with CCTV footage ನೀವು ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ವಾ, ಅದರಲ್ಲಿ ಇದಾನ ಅದರ್ assailants ಜೊತೆ ಇವನು? ವಾಹನಗಳಲ್ಲಿ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಎಲ್ಲಿದೆ ಮೆಟೀರಿಯಲ್ ಅಂತ, ಎಕ್ಸೆಪ್ಟ್ ದಟ್ ಮಾಜರ್ ಎಲ್ಲಿದೆ? ನಾನ್ ಕೇಳ್ತಾರೆ ನಿಮ್ CCTV ಫುಟೇಜ್ ಕವರ್ ಮಾಡಿದಿರಲ್ಲ ಅದರಲ್ಲಿ ಇದೆಯಾ, ಫೋಟೋಸ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅಥವಾ ಏನ್ರಲ್ಲಿ ಇದೆ? ಈ ಸ್ಟೋರಿ ಬಿಟ್ಬಿಡಿ, ಮಾಜರ್ ಅಲ್ಲಿ ಇದ್ರು ಅನ್ನೋದು ನೀವು CCTV ಫುಟೇಜ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದಿರಲ್ಲ, ಅದ್ರಲ್ಲಿ ಅಲಾಂಗ್ ವಿತ್ ಅಕ್ಯೂಸ್ ಪರ್ಸನ್ ಜೊತೆ ಇದಾನ ಅಂತ ನನ್ನ ಪ್ರಶ್ನೆ. ನಿಯರ್ ದಿ ಮುತ್ತೂಟ್ ಫೈನಾನ್ಸ್ ಅವತ್ತಿನ ದಿವಸ ಅಟ್ಲೀಸ್ಟ್ ಏನಾಯ್ತು ಮೇಡಮ್?
CCTV footage is recovered.
Recovered and this petitioner was present along with the other accused persons near the Muthoot Finance. But in order to substantiate the same, nothing is placed before the court except the measure regarding seizure of the CCTV footage. When the case is rested upon the circumstantial evidence and also when the petitioner is not at the place, and also the allegation against accused number is accused that he was conspired with accused number 2 and 3, and trial court already granted bail in favor of accused number 2 and 3, and this petitioner is also similarly placed against accused number 2 and 3. The very allegation of conspiracy has to be proved by examining the circumstantial witnesses, and court cannot expect the direct evidence. When such being the factual aspects of the case, the petitioner is entitled for bail with certain conditions.
Grateful, my lord.
74. Syed Akbar Pasha, head 3 and 5, 381 offense.
So far as what accused number 6 was mandatory what the remand was. Case number 30.
Page number 30. ಹೋದರೆ ಕಳವು ಮಾಡಿರುವ ವಸ್ತುಗಳನ್ನು ಬಚ್ಚಿಟ್ಟಿರುವ ಸ್ಥಳಗಳಲ್ಲಿ ತೋರಿಸಿ ಎತ್ತಿ ಕೊಡುತ್ತೇನೆ. ಏನದು ವರ್ತ್ ಎಷ್ಟ್ರಿ? ಅದು ವರ್ತ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ.
Property got as per the complaint got it is shown as not 1 crore.
What is that material?
The material got patte, mobile.
Oh, all ಇದು. Where he stored it? Where he stored it? ಮನೆಯಲ್ಲಿ. Recovery at the instance of this petitioner only. Yes, it's now 3 and 5. What is the role of 3 and 5? Our maneli did goods. He provided the place to keep the articles. Howda? Astana 3 and 5. Brothers ಆಯ್ತು.
Apart from that, my submission is just recording from A6. A6 discloses that this 385 have gave shelter with respect to
keeping the articles. ಅಷ್ಟೇ ಅಲ್ವಾ? Heard the petitioner counsel and also the counsel appearing for the petition. The factual matters of the case of the prosecution is that on 30/10/2021, the early morning 3:15 a.m. lorry container in KA 05 AD 956 loaded with articles from Amazon company, and same was taken by accused number 6.
Accused number 1.
Accused number 1, accused number 1. And the lorry was proceeded in a different destination as per the GPS track record. And found that the articles which were transported worth of rupees 1 crore 64 lakhs 56,711, and the same was stored in the house of accused number 3 and 5, and all of them joined together committing the offense, and hence case has been registered against the accused persons. The petitioners are accused number 3 and 5 before the court and sought for an anticipatory bail. The counsel appearing for the petitioner would submit that only allegation against these two petitioners that they have given accommodation to store the theft articles. And these petitioners are not aware of that those articles are theft articles. And these petitioners have not indulged in any such act except giving an accommodation to store the same. And hence they may be enlarged and bail. For contrary, the counsel appearing for the state would submit that these two petitioners are the brothers and they have given the accommodation to store the articles. And matter is under investigation whether these petitioners are also indulged along with other accused in committing the offence has to be probed, and hence their presence is required. For contrary, having heard the respective counsel and also taking into note of material facts available before the court, that is contents of the complaint government, the container was taken by accused number 1 and already recovery is made from 6, and only allegation made against these two petitioners that they have provided accommodation to store the articles. And having taken note of the said factual aspects of the case, I am of the opinion it is a fit case to exercise the powers and support 38 of CRPC with conditions, and the petitioners also assist and cooperate the IO for further investigation in the matter. 75.
Appear for petitioner, my lord.
Yes.
Yes,
last time, proclamation.
Proclamation. I produced the memo.
Proclamation ಆಗಿದೆಯಾ?
In the name of. But my respectful submission, your lordship.
Proclamation ಆಗಿದೆಯಾ ಇಲ್ಲ ಅಷ್ಟೇ ಹೇಳ್ರಿ?
ಆಗಿದೆ ಸ್ವಾಮಿ.
ಆಗಿದೆ. ಆದ್ರೆ ನೀವು you are not entitled for 438.
ಅಲ್ಲ ನಾನು ಸುಬ್ರಹ್ಮಣ್ಯ. I am not Subramani. My contention, I am money. I am falsely implicated. Respondent to apprehend me, then I go to the court for taking anticipatory bail, my lordship.
The proclamation issued against whom?
Subramani, I produced the memo.
Subramani, you are also in Subramani alias. That's, I think last time you can recollect your memory.
Not Subramani.
Pointed out in the lower court application, yourself has stated alias Subramani.
Why I am mentioning alias antandre? If I obtain the bail in the name of money, they are not allowed to.
That is matter of trial again. Identification. All the
document I produced, it is specifically stated as my name is Money, my lordship. I produce all the documents. Nowhere it is stated I am Subramani, and I am residing at.
Continue, counsel.
I am residing at Channagatte, my lordship.
But
the Subramani is residing at Channagatte. I am resident of Vannaragatte and Hanumat Nagara. It is mentioned in the election card and ration card, and also kindly peruse the page number.
Charge sheet ಅಲ್ಲಿ ಏನು ಹಾಕಿದ್ದಾರೆ ಅಡ್ರೆಸ್ ನಿಮ್ಮದು?
Charge sheet ಅಲ್ಲಿ Channagatte ಅಂತ ಹಾಕಿದ್ದಾರೆ ಸರ್. ಸುಬ್ರಹ್ಮಣ್ಯ Channagatte.
Channagattena ಜೇನುಗದ್ದೆನಾ?
Channagatte, my lord.
Channagatte ಆಯ್ತು. ನೀವು ಅಡ್ರೆಸ್ ಏನಿದೆ?
ನಾನು ವನ್ನಾರಗದ್ದೆ ಅಂತ ಇದೆ, ಹನುಮಂತ ನಗರ ಅಂತ ಇದೆ, ಹನುಮಂತ ನಗರ ಅಂತ ಇದೆ ಸರ್.
ಶೃಂಗೇರಿ ಇದೆ ಇದು. ನೀವು ಕೊಟ್ಟರೆ ಶೃಂಗೇರಿ.
ಅಲ್ಲ, ಎಲೆಕ್ಷನ್ ಐಡೆಂಟಿ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಯಾವಾಗಿದೆ ಎಲೆಕ್ಷನ್ ಐಡಿ ಕಾರ್ಡ್ ಹೇಳಿ? ಪೇಜ್ ನಂಬರ್ ಅಫೆನ್ಸ್ ಯಾವ ಇಯರ್ ರೀ?
ಅಫೆನ್ಸ್ ಇನ್ ದಿ ಇಯರ್
98. ನಿಮ್ಮ ಆಧಾರ್ ಕಾರ್ಡ್ ಯಾವ ವರ್ಷದ್ದು?
The 2018 my election
card. How it will helpful to you? Next, election ID card.
Election ID card mana.
ಯಾವ ವರ್ಷದ್ದು?
2018.
2018 ಆಮೇಲೆ
and also the
Incident 1987.
1997.
How you can rely upon those documents? Now you are not Mani or
For a
Subramani.
moment, kindly peruse the page number 40, my lordship. Page number 40.
40, yes.
Page number 40. ಮೇಲ್ಕಂಡ ವಿಷಯ ಉಲ್ಲೇಖದ ಈ ಮೂಲಕ ನಿವೇಶನಗಳು ಏನಂದ್ರೆ ಸುಬ್ರಹ್ಮಣ್ಯ ಅಕ್ಟ ಜೇನುಗದ್ದೆ ಅವರು ಬಾಳ್ಯ ವಿತರಣೆ ಮೇಲೆ ದಸ್ತಗಿರಿ ವಾರಂಟ್ ಅಷ್ಟು ವಾರಂಟ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಪ್ರಿನ್ಸಿಪಲ್ ಜೇಮ್ಸ್ ನ್ಯಾಯಾಲಯ ಬಂದಿದ್ದು ಸದರಿ ಆಸಾಮಿಯನ್ನು ಬಾಳೆಹೊನ್ನೂರು ಕಡಬಗೆರೆ ಸಂಗಮೇಶ್ವರ ಬಿಟ್ಟು ಜೇನುಗದ್ದೆ ಆರೋಪಿತರ ಬಗ್ಗೆ ವಿಚಾರಣೆ ಮಾಡಿ ಜೇನುಗದ್ದೆಯಲ್ಲಿ 6-7 ವರ್ಷಗಳ ಹಿಂದೆ
ಅಫೆನ್ಸ್ ಆದ್ಮೇಲೆ ನೀವು ಜಾಗ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟು ಈಗ ಅವೆಲ್ಲ ಕಾರಣಗಳು ಕೊಟ್ರೆ ಆಗುತ್ತೇನ್ರಿ? ಆಯ್ತು ತೊಳಿ.
6-7 ವರ್ಷದಿಂದ ಅವರು ನಾನು I am not absconded from anything for any place apart from my native place.
ಏನೇ ನೀವು ಅಬ್ಸ್ಕಾಂಡ್ ಮಾಡಿದಿರೋ ಇಲ್ವೋ ನಾನ್ ಮಾಡಕ್ಕ ಎಕ್ಸಾಮಿನ್ ಮಾಡಕ್ಕಲ್ಲ. ಸಿಟ್ಟಿಂಗ್ ಪಿಟಿಷನ್ ಪ್ರೊಕ್ಲಮೇಷನ್ is issued against you. 438 is not written.
Crime was registered against Subramani and proclamation was issued against the Subramani, not against the money. My name is Mani, my lordship.
I thought heard the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that on 5/3/1998, when the respondent forest officials were on patrolling duty near Hebbe wildlife range during night, they found clients carrying some bags from Deepada Gudda side. Full stop. They had seen them in the headlight of the jeep. They stopped the vehicle. Then the person carrying the bags threw the bags and made an attempt to escape. They were able to apprehend 2 persons, 4 other persons escaped. They brought them to the police place where they threw the bags. On inquiry, they disclosed that PM, Hegde Gowda Chandru were accused number 1 and 2, and they also given the details of 4 Subramanya, son of Venkatachala, Sangameshwara Pete. They found 74 sandalwood billets and also pieces in the bag, totally weighing 172 kgs. The case has been registered against in total 4 accused persons.
Yes,
4 accused persons. 4 accused persons, and police have also investigated the matter and filed the charge sheet, and accused number 4 has not been secured. The counsel appearing to the petitioner would submit that this petitioner has approached the trial court by filing criminal misdemeanor number 837 of 21, and trial court has rejected the bail petition on the ground that this petitioner has been absconded, and the counsel would submit that his name is Mani and not Subramani. And in support of his contention, he also relied upon the Aadhaar card and also the election ID card, and submits that he is not Subramani, he is a Mani, and also place of residence is also different, and hence he may be admitted to the 438 petition. Work under the counsel appearing to the state would submit that the incident was taken place in 1998 when 2 accused persons were apprehended. On the date of the incident itself, accused number 1 and 2 have revealed the name of this petitioner, Subramanya, son of Venkatachala. Venkatachala. And only on information collected by co-accused persons, this petitioner has been arraigned as an accused number 4. And hence the very contention that he is Mani, not Subramani, cannot be accepted, and counsel also relying upon the document subsequent to the incident, and the same cannot be relied upon. Having heard the respective counsel and also on perusal of material, the petitioner before the trial court also, while seeking anticipatory bail, mentioned the name as Mani alias Subramani, but father name is one and the same, that Venkatachala. And now counsel is relying upon the Aadhaar card and also the election ID card, which are subsequent to the date of incident, and those documents cannot be relied upon. And material also discloses that the proclamation is issued against this petitioner. When such being the case, the petitioner cannot maintain a petition under 438 of CRPC seeking an anticipatory bail when the proclamation is issued against him. The identity of the accused, which the petitioner now disputes, the same is a matter of trial, and now this court cannot decide the same. Approach Pasha. A to roll Henry. ಆಯ್ತು, ರೋಲ್ ಏನು ಅಂತ ಕೇಳಿದೆ. ಯು ಆರ್ ರನ್ನಿಂಗ್ ಬ್ರಾತೆಲ್ ಏನು? You are the agent. As per the charge sheet. Go to page number 24, charge sheet. You know, accused number 1 alva? 2 na? 2, A2. ಎಲ್ಲ ಓದೋದು ಬೇಡ್ರಿ, A2 ಮಾತ್ರ ಹೇಳಿ. ಏನಿದೆ A2 ಮೇಲೆ ಅಲಿಗೇಷನ್? A1, A2, A3 ರವರು ಸೇರಿ ಸಾಕ್ಷಿ 1 ರವರ ಮೇಲೆ ಹಲವಾರು ಬಾರಿ ಅತ್ಯಾಚಾರ ಮಾಡಿದ್ದು ಅಂತ ನಿಮ್ಮೇಲೂ ಇದೆ ನೋಡಿ. ಹೌದಾ? ಸಾಕ್ಷಿ 1 ರವರನ್ನು ರೂಮಿನಲ್ಲಿ ಕೂಡಿ ಹಾಕಿ ತಮ್ಮ ಕೈಗಳಿಂದ ಹೊಡೆದು ಇನ್ನೊಂದು ಬಿಡಬೇಕಂದ್ರೆ ನೀನು ನಿಮ್ಮ ತಂದೆಗೆ ಫೋನ್ ಮಾಡಿ 10 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಕೊಡಬೇಕೆಂದು ಒತ್ತಾಯಿಸಿರುತ್ತಾರೆ. ಹೌದಾ? HCPC 3 days time and hence this matter on 21st. 77 Mahesh and company. A3 and 4.
Just say no. One company called as Sanities. This company was allotted around 10 acres land from KID. The company had deposited 10 crores. Totally 25 crores company deposited. Return the lands.
Return
the lands back to the KID. Because there was certain dispute between KIDP and the company, where these two petitions were the directors at that point of time. That money was given back. KSFC had given the loan of 14 crores to the company. So our company now return money. KSFC very long. KSFC after 4 years finally criminal complaint. ಎಲ್ಲ ಹೋಗಿ ನಡೀತಾ ಇದೆ. ಅಕಾಲ ಕೊಟ್ಟಿಲ್ಲಿ ಈಗ ಬರೀ 3 ಕೋಟಿ ಭಾಗ ಬಿದ್ದಿರೋದು ಎಲ್ಲ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. KDP ಆದ್ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹೋಗಿ ಸಾರಿ KSFC ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಯ್ತು.
KSFC ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಯ್ತು.
KSFC ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ
ಚಾರ್ಜ್ ಶೀಟ್ ಆಯ್ತು against these petitioners ಆಯ್ತು.
ಅದರ ನಂತರ ನಾವು KDP as well as same complaint saying that KSFC have been cheated. ಇವ್ರು ಚೀಟ್ ಆಗಿಲ್ಲ, KDP ಚೀಟ್ ಆಗಿಲ್ಲ, KSFC ಚೀಟ್ ಆಗಿದೆ ಅಂತ ಮತ್ತೊಂದು ಕಂಪ್ಲೇಂಟ್ ಅದ್ರ ಮೇಲೆ ಸಾರ್ಟ್ ಫಾರ್ ಟ್ಯಾಕ್ಸ್.
This case to Jellicoe PS. And your last directed the council on the last date appearing for the petitioner. Start trying to clarify about that aspect.
ಏನೋ PT ಅಂತಿದೆ, ಪ್ರೇಸ್ ಟೈಮ್ ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೀನಿ ನಾನು.
So they are required to clarify. As per our records, this crime was originally transferred to Jellicoe PS. Wherein in Jellicoe PS also crime number 154 was registered, and in that they have already taken the respective thing.
ಅದರಲ್ಲಿ ಈಗ ಅವ್ರು ಹೇಳೋದೇನು, ಒಂದ್ ಕಡೆ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಆಯ್ತು, ಜೂರಿಸ್ಟಿಕ್ಷನಲ್ ಪಾಯಿಂಟ್ ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಯ್ತು ಜಯನಗರ್ ಅಲ್ಲಿ ಅಂತ. ಆ ಜಯನಗರ್ ಅಲ್ಲಿ ಈಗ ಕೇಸ್ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ, ಕ್ರೈಮ್ ನಂಬರ್ ಅಲ್ಲಿ ಸಪರೇಟ್ ಕ್ರೈಮ್ ಕೊಟ್ಟಿರ್ತಾರೆ. ಆ ಕೇಸಲ್ಲಿ ನೀವು ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಿ ಅಂತ ಅವರು ಅದಕ್ಕೋಸ್ಕರ ವೆರಿಫೈ ಮಾಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ರಿಮೆಂಬರ್. ನೋಡಿ ಅದು ವೆರಿಫೈ ಮಾಡಿ ಸಬ್ಮಿಟ್ ಮಾಡಿ. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಟು ವೆರಿಫೈ ವೆದರ್ ಆಲ್ರೆಡಿ 438 ರಿಲೀಫ್ is taken in the transferred crime number. ಅದೇ ಟ್ರಾನ್ಸ್ಫರ್ಡ್ ಕ್ರೈಮ್ ನಂಬರ್. ಈ ಕೇಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಜಯನಗರದಲ್ಲಿ ನ್ಯೂ ನಂಬರ್ ಆಗಿದೆ ಅಂತ. ನಾವು ನ್ಯೂ ಕಾನ್ಸೆಪ್ಟ್ ಈಸ್ 0 FIR. ದಟ್ ಮೀನ್ಸ್ ಜೂರಿಸ್ಟಿಕ್ಷನ್ ಫ್ರೀ. ಎಲ್ಲೇ ಆಗ್ಲಿ, ಎಲ್ಲೇ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಬಂದ್ರೆ ಕಾಗ್ನಿಸಬಲ್ ಅಫೆನ್ಸ್ ಆದ್ರೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಕನ್ಸರ್ನ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಗೆ ಅವ್ರು ಕಳಿಸ್ಕೊಡ್ಬೇಕು. ದಟ್ ಈಸ್ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ 0 FIR. ಅದನ್ನ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಮೋಸ್ಟ್ಲಿ. ಆಯ್ತು ನೋಡೋಣ. ಆಯ್ತು 21st ಲಕ್ಷ್ಮೀಕಾಂತ್ 21st ಕೊಟ್ಟಿದ್ದೀನಿ ಡೇಟ್. 302 120B 143 ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ. ತಗೊಳ್ಳಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. GP6 ಟೈಮ್ ಏನ್ರಿ, ಮತ್ತೆ ಎಷ್ಟು ಸರಿ ಟೈಮ್ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ? 25/1 ನಿಮ್ಗೆ 3:2 ಅಂತ ಇತ್ತು. 2:30 ಯಾರು ಬರ್ತಾರೆ? ನೀವು ಒಬ್ಬರೇ ಬರ್ಬೇಕಷ್ಟೇ. ಹಾ, ನೀವು ಬರಲ್ಲ, ಅವರು ಬರಲ್ಲ, ನಾನು ಇರಲ್ಲ. ಆಯ್ತು. ಏನೈನಲ್ರಿ ಇವನೇ ಏನೈನು 80 ಬೇಲ್ ಆಗಿದೆ. ನಾನು ಇಲ್ಲಿ ಏನೈನದ್ ಬರ್ದಿದ್ದೀನಿ ಅದು ಕೇಳಿ. ಆಯ್ತು, 2 ದಿವಸ ನೋಡೋಣ. 438 ಅಲ್ಲಿ ಕೇಳಿದಿರಿ 302 ಅಲಿಗೇಷನ್ ಏನು ಅಂತ ನೋಡ್ಬೇಕಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಂಗೆ ಇದೆಯಲ್ರಿ, ಎಲ್ಲ ಹಾಕಿದಾರ ಅವರು. ಎಲ್ಲ ಹಾಕಿದ್ಮೇಲೆ ನಿಮ್ಗೆ ಇನ್ನೇನ್ ಬೇಕು ಇನ್ಫಾರ್ಮೇಶನ್? ಚಾರ್ಜ್ ಶೀಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರಿ, ಎಂಟೈರ್ ಕಾಪಿ ಕೊಟ್ಟಿದಾರ ಇಲ್ಲ ನಿಮ್ಗೆ? ಕೊಟ್ಟಿದಾರ ಇಲ್ಲ ನಿಮ್ಗೆ? ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಇಲ್ಲ? HCGP 6 time ಡಿಸ್ಕಸ್ ಮಾಡಿ ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ನಾಟ್ 21st, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲೇ ಕೊಡಿ. 17th. ಮತ್ತೆ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ, ಇರೋ ಮೆಟೀರಿಯಲ್ ಮೇಲೆ ಆರ್ಡರ್ಸ್. ನೆಕ್ಸ್ಟ್ ನವೀದ್ ಅಹಮದ್ 354 506 ಅಷ್ಟೇ ಏನ್ರಿ? ಓನ್ಲಿ 2 offenses ನೋಡಿ. Heard the Petitioner Council and also the Council of Parents of the State. ಅದಕ್ಕೇನು 100 page ಬೇಲ್ ಆರ್ಡರ್, ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್? ಪೇಜ್ ಮೇಲೆ ಫೀಸಾ? ಅಲ್ಲ, ಒಂದು 354 506 ಅಫೆನ್ಸ್ಗೆ ನೀವು 12 ಪೇಜ್ ಒಂದು ಬೇಲ್ ಪಿಟಿಷನ್ ಅಂತಂದ್ರೆ ಏನ್? Heard the Petitioner Council and also the Council of Parents of the State. The factual matters of the case of the prosecution is that the complainant husband passed away. And, the petitioner, who is working as director in the hospital, knowing the same very well, is outraged in the modesty of a woman, outraged in the modesty of the complainant, and he is insisting that if she compromises with him, he would give rupees 2 to 3 lakhs. And hence he has lodged the complaint. Now, based on the complaint, police I have registered the case and matter is under investigation. ಏನು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲಲ್ಲ? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ಲ. Investigation. The counsel appearing for the petitioner would submit that both are working together and false allegation is made that and no such allegation is no such incident is taken place as narrated in the complaint. And with malafide intention, the present complaint is filed. The offences are also not punishable with death or imprisonment for life, and hence he may be enlarged on bail. For contrary, the counsel appearing for the state would submit that the complaint clearly discloses that both of them working together, and this petitioner being the director of the hospital, subjecting the complainant for the modesty of a woman, and it is a serious offense against a woman, and there is a prima facie case. Having heard the petitioner counsel and also looking into the material available on record, particularly the complaint dated 5/1/2022, an allegation is made against this petitioner that he being the director subjected her for increasing the modesty. Allegation is made and both of them are working in the same place. The matter has to be probed and looking into the factual aspects as well as the allegations made in the complaint and nature of the offense, it is a fit case to exercise the powers which report the date of CRPC. 80. Vinuthan Murthy.
For petitioner, my lord.
Yes, counsel.
Criminal
Charge sheet agide illa?
No charge sheet has been filed, my lord.
Crime stage,
yeah, it's bail.
SC/ST ಇನ್ವೋಕ್ ಆಗಿದೆಯಾ? ಜೂರಿಸ್ಡಿಕ್ಷನ್ SC/ST ಇನ್ವೋಕ್ ಮಾಡಿದಾರಂತೆ ನೋಡಿ. ಏನ್ ತಗೊಳ್ಳಿ, HCGP ಏನ್ ನೀವೇನ್ ಟೈಪ್ ಕೇಳ್ತಾ ಇದ್ರ? ಏನು ಆಗಿ SC/ST ಆಗ್ಲೇ ಇನ್ವೋಕ್ ಆಗಿದೆಯಾ? SC/ST ಅಫೆನ್ಸ್ ಇನ್ವೋಕ್ ಆಗಿದೆ ಅಂತ ನೋಡ್ರಿ. ಪಿಟಿಷನ್ ಮೇಂಟೈನ್ ಆಗಲ್ಲ, ಅಪೀಲ್ ಹಾಕ್ಬೇಕಾಗ ನೀವು ನೋಡಿ. HCGP submits that the SC/ST special act is invoked and hence petition is not maintainable, and hence petitioner counsel seeks time to make mention with regard to the same and list this matter on 17th ನೋಡಿ. Short date ಕೊಟ್ಟಿದ್ದೀನಿ.
Okay, madam. Obliged.
Gajendra CV Last time no representation. Pass over. 82. Dilraj Rohit. Dilraj Rohit.
I pay for the petitioner lordship.
Yes, madam.
The charge sheet. The same I produced before your lordship. I seek for a week's time.
No, madam. Last time also pretty press time on the ground that charge sheet is filed.
Since we have received the charge sheet, your lordship.
Have you filed the charge sheet or not?
No. Yesterday only we have received. Seek for a week's time, your lordship. May kindly have it on Wednesday or Tuesday. I'll produce your lordship.
Petitioner counsel would submit that yesterday they have received the charge sheet materials and hence seeks 2 days time to place before the court. And hence both matters.
Yeah.
This is matter on 21st.
We have filed a
this matter on 21st and petitioner counsel is directed to place the charge sheet material today itself in the office since last occasion also took the time on the same ground.
Please.
83 in the same.
We have filed a memo of withdrawal, your lordship. The police have.
What is the reason for withdrawal?
They have filed a charge sheet and it has been numbered as CC number 31 of 2022.
Trial court. Memo filed up seeking permission to withdraw the petition on the ground that already investigation has been completed and charge sheet filed and the petitioner may be given liberty to approach the trial court. In view of the submission permitted to withdraw. Next 85. 84. 84. KB Satisha. Yeah. 465, 468, 471. ಏನು manipulation of passport, Foreigners Act ಇದೆ. Charge sheet also filed. Where is that charge sheet? Page number 26. ಆರೋಪಿಯನ್ನು ದಿನಾಂಕ 26/10/90 ಹಗಲು ಆಧಾರದ ಸಾಕ್ಷಿ 1 ವರ್ಷಕ್ಕೆ ನೀಡಿದ್ದು ಆರೋಪಿಯ ದಿನಾಂಕ 25 ರಾತ್ರಿ 2:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ವಿಮಾನ ಸಂಸ್ಥೆ ಬೆಂಗಳೂರಿನಿಂದ ಅಬುದಾಬಿಗೆ ಟೂರಿಸ್ಟ್ ವೀಸಾ ರಡಿಯಲ್ಲಿ ಪ್ರಯಾಣಿಸಲು ಬಂದಿದ್ದು ಇಮಿಗ್ರೇಷನ್ ಕ್ಲಿಯರೆನ್ಸ್ ಗಾಗಿ ರಹದಾರಿ ಪತ್ರ ದಾಖಲಾತಿಗಳನ್ನು ಸಾಕ್ಷಿಗಳು ಹಾಜರುಪಡಿಸಿ ಅದರಿ ದಾಖಲಾತಿಗಳು ಅನುಮಾನ ವಿಚಾರಣೆಯಾಗಿ ಪ್ರಜೆಯಾಗಿದ್ದು ಅವ್ರ ತಂದೆ ತೀರಿಕೊಂಡ ನಂತರ ಅವ್ರ ತಾಯಿ ಭಾರತೀಯ ಪ್ರಜೆಯಾಗಿ ಮದುವೆಯಾಗಿ ಭಾರತಕ್ಕೆ ವಲಸೆ ಬಂದು ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತಲ್ವ ಇದು ಬೆಂಗಳೂರಿನ ಜೆಪಿ ನಗರದಲ್ಲಿ ನೆಲೆಸಿದ್ದು ಆ ಸಮಯದಲ್ಲಿ ಆರೋಪಿಗಳು ತನ್ನ ಬಾಂಗ್ಲಾದೇಶದ ಪಾಸ್ಪೋರ್ಟ್ ನಂಬರ್ ಅನ್ನು ಬಳಸಿ ಅಕ್ರಮವಾಗಿ ತನ್ನ ತಾಯಿ ವಿಳಾಸದಲ್ಲಿ ನೆಲೆಸಿದ್ದ ವೋಟರ್ ಐಡಿಯನ್ನು ಮಾಡಿಸಿಕೊಂಡು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಭಾರತೀಯ ರಹದಾರಿ manipulation and forgery of document. Everything is correct, but why he indulged in manipulation of documents? Authority. When those documents are produced, those documents are fake documents. And those documents are also those documents are forged documents. You only fabricated those documents and used those documents and placed before the airport authority.
His mother was married to
Indian. ಆಯ್ತು. ಸುಳ್ಳು ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ಅವುಗಳ ನೈಜವಾದುದೆಂದು ಬಳಸಿ ಭಾರತೀಯ ರಹದಾರಿ ಪತ್ರವನ್ನು ಮಾಡಿಸಿಕೊಂಡು ಬಾಂಗ್ಲಾದೇಶಕ್ಕೆ ಹೋಗಿ ಬಂದಿದ್ದು ಇಂಡಿಯನ್ ಟೂರಿಸ್ಟ್ ವೀಸಾದಲ್ಲಿ 90 ದಿನವಿರಲು ಷರತ್ತು ವಿಧಿಸಿದ್ದು ವೀಸಾ ನಿಯಮವನ್ನು ಕೂಡ ಉಲ್ಲಂಘಿಸಿ ಆಲ್ let him be there. Let him be there inside. Committal case already committed. You are in custody from 21. ಯಾವ ಡೇಟ್ ಹೇಳ್ರಿ? 21 ಮೊನ್ನೆ ಆಗಿರೋದು 26/10 FIR ಆಗಿರೋದು 26/10 ಅಲ್ಲಿ. ಅವತ್ತೇ ಅವನನ್ನು ಕಸ್ಟಡಿ ತಗೊಂಡಿದ್ದಾರೆ. When he tried to travel based on the fake documents. Heard the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that on the intervening night 25/26 10/21 at about 11:35 p.m. when the petitioner approached the immigration clearance counter at Bangalore in the international airport to travel to Abu Dhabi by Air India flight number AI 1977. So on verification and questioning of the petitioner, it found that petitioner is Bangladeshi national and illegally crossed the border through Jarkhalli village, West Bengal, and obtained Indian passport during his stay in Bangalore fraudulently, thereby committed here an offences. Hence, the case has been registered and matter is investigated and filed a charge sheet against the petitioner for the offences punishment 465, 468, 471 of IPC and section 12(1)(a), AB of Passport Act and also 14(ab) and 14(b) of Foreigners Act. Counsel appearing for the petitioner would submit that petitioner is an innocent and his mother married an Indian and mother is staying in Bangalore, and the allegations made in the charge sheet not supported by any material, and the petitioner is staying with his mother and stepfather since several years. And he had also enrolled his Aadhaar card and also obtained passport through agency, and he has not committed any offences. This petitioner is in custody from 26/10/2021, and when the investigation has been completed, no need of custody. Per contra, the counsel appearing for the state would submit that first of all, this petitioner is not Indian and he is the national of Bangladesh, and he had indulged in creation of documents, and apart from that, fabricated the documents and made use of those documents travel from Bangalore to Abu Dhabi. And when he made an attempt to travel at that time, on verification, the authority comes to know that those documents are not genuine, and when he was taken to custody. And during the investigation also, the material is collected that those documents are fabricated documents and made use of the same. And there is a prima facie case. Having heard the respective counsel and also on perusal of material available on record, particularly specific allegation is made that he has violated Indian Passport Act 1967, particular section 12(1)(a). And first of all, he is not a citizen of India, and he makes an application for a passport and also obtains a passport by suppressing the information about his nationality. And though the offence is liable to be punished with imprisonment for a term which may extend to 5 years and also fine not less than 10,000, which may extend to 50,000. And apart from that, the very allegation, he indulged in fabrication of document and made use of those documents. So hence other offences including 465, 468 and 471 are also invoked. That is, using of those documents are concocted, and such serious allegation is made, and this petitioner is also not an Indian national and is a national of Bangladesh, and taking into note of seriousness of offences, not a fit case to exercise the powers under 439 of CRPC. The other contention that already investigation has been completed and charge sheet is filed, and the same cannot be a ground to enlarge him on bail, though the offences are not punishable with death or imprisonment for life. Timmanna, Karnataka private medical last time ಏನೋ ಇದ್ದಂಗಿರಲಿಲ್ಲ ಯಾರು ಇದರಲ್ಲಿ ನೋಡಿ ಮೇಡಮ್, ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಅಲ್ಲ, ಲಾಸ್ಟ್ ಟೈಮ್ ಇರಲಿಲ್ಲ, ಅದೇ ಬೇರೆನಾ ಫಸ್ಟ್ ಟೈಮ್ ಮೇಡಮ್? ಇದು ಹಾಕಿದಾರಲ್ಲ, ಏನೋ ಸಿಟೇಷನ್ಸ್ ಎಲ್ಲ ಹಾಕಿದಾರೆ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ? ಈಗ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ? ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 21st. ರಾಧಾಕೃಷ್ಣ, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸರ್ ರಿಗಾರ್ಡಿಂಗ್ ಮೇಂಟೈನಬಿಲಿಟಿ ಏನೋ 2 ಕೇಸಸ್ ಇದ್ದಂಗಿದೆ. ಹಾ, ಇನ್ನೊಬ್ರು ಯಾರು ಹಾಕಿದಾರಲ್ಲ? ಹಾ, ನೀವೀಗೇನು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಮೇಲೆ ಹಾಕಿದ್ದೀರಾ? ಹಾ, ಫಸ್ಟ್ ಯಾರಿಗೆ? ಫಸ್ಟ್ ಪಿಟಿಷನ್. ಹಾ, ನೀವೀಗ ಯಾರಿಗೆ ಹಾಕಿದ್ದೀರಿ? 1 and 2 ಇಬ್ರಿಗೂ ಹಾಕಿದಿರಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ ನೋಡಿ ಮೇಡಮ್, ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಅಬ್ಸೆಂಟ್ ಅಂತಿದ್ಯಾ? because there are two ಇದೆಯಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ. ನೀವು ಪಾರ್ಟಿಗೆ ಹೇಳೋದು ಏನ್ ಮಾಡಿಸ್ಕೋಬೇಕು ಅದು ಮಾಡಿಸ್ಕೋಬೇಕು ನೀವು. ನಂಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು. But when there are two petitions, I cannot proceed with. ಹೇಳಿ. ಆಯ್ತು ತೊಗೊಳ್ಳಿ. ಆಯ್ತು. The council in criminal petition 8087/21. Last time ಏನಾಗಿದೆ ನೋಡಿ ಮೇಡಮ್. ಅದಾಯ್ತು ಮೇಡಮ್, ಅವ್ರದ್ದಾಯ್ತು ಅದು, ಇವ್ರದ್ದು 8087/2021 is absent. ಈ ಕ್ಲಬ್ ಆಗಿದೆಯಲ್ವಾ ಎರಡುವೆ? ಯಾವಾಗದು? ಅಕ್ಟೋಬರ್. ಯಾವಾಗಿಂದ ಬರ್ತಾ ಇಲ್ಲ. ಏನಾಯ್ತು ಮೇಡಮ್? ಅದು ಆಫೀಸ್. And when the matter was listed, when an opportunity was given in the month of October for compliance of office objection, till date the office objections are not complied, and counsel also not appearing before this court. 671/2022 so submits that he had filed this petition after filing of charge sheet on behalf of petitioner number accused number 1 and 2. 1 and 2. 1 and 2. And earlier petition is only on behalf of accused number 1. 1. Having having considered the submission, and counsel on record in criminal petition number 8087/2021 is not pursuing the matter. However, an opportunity is given to make a submission, or otherwise the said petition will be dismissed in the next date of hearing. Date kodi on 21st. 22nd. ಹೌದಾ? 22 ಆಯ್ತು. 22nd. ಸಿರಾಜುದ್ದೀನ್ ಅಹಮದ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಕೇಳಿದ್ವಿ ನೋಡ್ರಿ. ಏನು ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಆಫೆನ್ಸ್ ಏನು? ಸಿರಾಜುದ್ದೀನ್ ಅಹಮದ್ ಇಲ್ವಾ? ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ತಂದಿದ್ದೀರಾ? ತಂದು ನೋಡಿ.
My lordship, kindly pass over the matter.
No pass over, madam. Time already 1:45.
My lordship, my senior has
ಆಯ್ತು. petitioner counsel 6 time ನೀವು antecedent ತರಿಸ್ಕೊಳ್ರಿ. And HCGP also directed to get the antecedents as directed. This matter on 21st. Next, Girish S. Hegde 323, 376, 4 and 6, 9 and 10. ಏನು what is our age? 14 years 8 months. ಪಿಟಿಷನರ್ ಯಾರು? ಗಂಡನ? ಆಯ್ತು ಹೇಳಿ. ಕೀರ್ತನೆ 14 ವರ್ಷದ 8 ತಿಂಗಳ ಹುಡುಗಿ ಗಂಡನ ಕಿರುಕುಳ ನೀಡಿ ಹೊಡೆದಿರುತ್ತಾರೆ ಬಂದಿರುತ್ತಾರೆ ತಿಳಿಸಿದರು. ನಾನು ಹೋಗಿ ಬಾಲಕಿಯನ್ನು ವಿಚಾರಣೆ ಮಾಡುತ್ತೇನೆ. ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ತನ್ನ ತಾಯಿ ಜೊತೆಯಲ್ಲಿ ಕನಕಪುರ ತಾಲೂಕು ಅರವಳ್ಳಿ ನಮ್ಮ ಗುಡಿಯ ಮನೆ ವಾಸವಿದ್ದ ಮಂಡ್ಯದಲ್ಲಿ 9ನೇ ತರಗತಿ ಓದುತ್ತಿದ್ದನು. ನನಗೆ ಇರುವಂತ ಬೇರೆಗಳ ತಾಯಿ ತಮ್ಮದೇ ರಾಧ ಮತ್ತು ಅವರು ಗಂಡ ಸೇರಿಕೊಂಡು ಬೇರೆಗಳಲ್ಲಿ ವಾಸಿದ ಯಾವಪ್ಪ ನಮ್ಮ ತಾಯಿ ಜೊತೆ ರೂಪಾ ಜೊತೆಯಲ್ಲಿ ಮಾತುಕತೆ ಮಾಡಿಕೊಂಡು 21/6 ತಮಿಳುನಾಡಿನ ವಾಸಿದ ಯಾವಪ್ಪ ಎಂಬುವರ ಮಗ ಸೋನ್ಸೋ ಎಂಬುವರಿಗೆ ಮದುವೆ ಮಾಡಿದ್ರು. ನಂತರ ಬೈರಗೊಂಡನ ಹೊಡೆದು ಕಿರುಕುಳ ನೀಡಿದರು ಅಂತ ಹೇಳುತ್ತಾರೆ. ಆಯ್ತು. ದಿಸ್ ಇಸ್ ಕಂಪ್ಲೇಂಟ್ ಬೈ ಯಾರು? CDPO-ನಾ? ಅಲ್ಲ ರೀ, ಸಹಿ ಇದೆ. ಸರಸ್ವತಿ ಯಾರು? ಕಂಪ್ಲೇಂಟ್ ವಿಕ್ಟಿಮ್ ಅಲ್ಲಲ್ಲ, ವಿಕ್ಟಿಮ್ ಸಂಸ್ಥೆ ಹೇಳಿಕೆ ಏನ್ರಿ? 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾನ್ರಿ ಅವಳು? ಆಯ್ತು.
27 ವರ್ಷ ಅಂತ ಹೇಳಿ ಅವನ ಜೊತೆ ಮದುವೆ ಮಾಡಿಸುತ್ತಾರೆ. ಅನಂತರ ಅವನಿಗೆ 30 ವರ್ಷ ಬರ್ತಾ ಇದ್ರು. ಆಗ ನನ್ನ ಪ್ರಶ್ನೆ ಮಾಡಿಕೊಳ್ಳುವಂತೆ ನನ್ನ ಅತ್ತೆ ರಾಧಾ ಹೇಳಿದ್ರು. ನಾನು ಪ್ರಶ್ನೆ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದಾರೆ, ನನ್ನನ್ನು ಲಾಠಿಯ ಸೇರಿಸುವುದು ಹೇಳಿ ನನ್ನನ್ನು ತಳ್ಳಿದ್ರು. ಆಗ ನಾನು ಪ್ರಶ್ನೆ ಮಾಡಿಕೊಂಡೆ. ಆನಂತರ ಮತ್ತೆ
ಎಲ್ಲಿಗೆ ತಳ್ತೀನಿ? ಲಾಡ್ಜಿಗೆ. ಅಂದ್ರೆ ಪ್ರಾಸ್ಟಿಟ್ಯೂಷನ್ ಮಾಡಕ್ ಕಳಿಸ್ತೀನಿ ಅಂತ. ಆಯ್ತು, ಹೇಳಿ ನೆಕ್ಸ್ಟ್. ಅಷ್ಟೇನಾ? ಈಗ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ? ಏನ್ರಿ 14 ವರ್ಷ?
The petitioner and the family was given an impression that she has studied up to 9th standard.
ಆಯ್ತು ಅದೆಲ್ಲ ಆಯ್ತು.
ಅವ್ರು ರೂಪದಲ್ಲಿ 14% ವಿಚಾರ ನಮಗೆ ತಿಳಿಸಿರಲಿಲ್ಲ.
ಆಯ್ತು.
ನಾನು ಮದುವೆ ಮಾಡಿದ ಪೇರಾಗ್ರಾಫ್ನ ಹಾಕಿ this is the consent of the elders of the family. Includes ಆಯ್ತಲ್ಲ ಇಂಕ್ಲೂಡ್ ಮದುವೆ ಮಾಡಿ. And the last thing is to see. 2nd of September 2021 statement. 1 month prior to that. There was a penetrative assault. Sentence again.
Other petitions are other petitions ಹಾಕಿಲ್ಲ ನೀವು ಓನ್ಲಿ ಹಸ್ಬೆಂಡಿಗೆ ಮಾತ್ರ ಹಾಕಿದ್ರು. Statement is clear that she was forcibly ಎಲ್ಲಿದ್ದಾರೆ ಕೊಡ್ರಿ ಅದು 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡೋಣ. ಈ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಆಕೆ ಏನು ಅಲಿಗೇಷನ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್ ಇಸ್ ವೆಲ್ ಅಂಡ್ ಗುಡ್. ಬಟ್ ಈಗ ಏನ್ ಮಾಡ್ತೀರಿ, ಈಗ ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್ಸ್ ಇದೆ. ಅಲ್ಲ ರೀ, PDO ಹೆಂಗ್ ಗೊತ್ತಿರುತ್ರಿ ಏನಾಗಿದೆ ಎಲ್ಲ. ಓನ್ಲಿ ವೆನ್ ಹಿ ಕಮ್ಸ್ ಟು ನೋ ದಟ್ ಮೈನರ್ ಮ್ಯಾರಿಡ್ ಗೊತ್ತಾಗ್ತದಲ್ಲ ಅವಾಗ ನೋಡಿ. ಬೇಡ ಎಂದು ಹೇಳಿದ್ರು ಕೇಳದೆ, ನಾನು ಹೆಚ್ಚಿಗೆ ಓದ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು ಚೆನ್ನಾಗಿ ಓದ್ಬೇಕು, ಮದುವೆ ಮಾಡುವುದು ಬೇಡ ಎಂದು ಹೇಳಿದರು ಕೂಡ ಕೇಳದೆ, ಅವ್ರು ನನ್ನ ಮದುವೆಯನ್ನು ದೇವಪ್ಪರ್ ಅವ್ರ ಮಗನಿಗೆ 27 ವರ್ಷ ಎಂದು ಹೇಳಿ ಮದುವೆ ಮಾಡ್ತಾರೆ. ನನ್ನ ವಯಸ್ಸು 30 ಗೊತ್ತಾಯ್ತು. ರಾಧಾ ಹೇಳಿದ್ರು ನಾನು ಏಕೆ ಓದಿಸೋದು ಮನುಷ್ಯ ಎಂದು ತಂದೆ ತಾಯಿ ಹೇಳಿದ್ರು. ಅಲಿಗೇಷನ್ಸ್ ನೋಡಿ ಎಲ್ಲ ಇವ್ರ ಮೇಲೆ. ನನಗೆ ಎಷ್ಟು ವಯಸ್ಸಿಂದ ಮದುವೆ ಆಗಿದೆ ಎಂದು ಕೇಳಿದಾಗ ನನಗೆ 15 ವರ್ಷದಿಂದ ಆಗಿದೆ ಅಂತ ಹೇಳಿದಕ್ಕೆ ಮಹಿಳಾ ಸಂಘದವ್ರನ್ನು ಕರೆಸಿದ್ರು. ನಾನು ಕಳಿಸಿದ್ರೆ ಚಿತ್ರಾಂಶ ಕೊಡುತ್ತೇನೆ, ನಾನು ಪೊಲೀಸರಿಗೆ ದೂರು ಕೊಡುತ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ದು. ಆಗ ಅವರು ನಾವು ನೋಡದೇ ಇರುವ ಪೊಲೀಸರೇ ಎಂದು ಹೇಳಿದ್ರು. ಅದು ಬೇರೆ. ದಿ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಆಲ್ಸೋ ಹಸ್ಬೆಂಡ್ ಅಂತ ಹೆಂಗ ಮಾಡ್ತೀರಿ? 14 ವರ್ಷದ ಹುಡುಗಿಗೆ ಹಸ್ಬೆಂಡ್ ನೀವು ಅಂತ ಹೇಳಿ ಹೆಂಗ್ ಕ್ಲೇಮ್ ಮಾಡ್ತೀರಿ? Heard the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that the victim girl, who is aged about 14 years 8 months, marriage was solemnized with this petitioner, knowing fully well that the victim is a minor, and when the victim girl refused to cohabit with this petitioner, caused threat and subjected her for sexual act. On the CDPO, complaint case has been registered, and thereafter victim statement is also recorded under 164 of CRPC, wherein also she made the allegation reiterating the same, and hence matter is under investigation and not yet completed the investigation. Counsel appearing for the petitioner would submit that this petitioner is not aware of the age of the victim, and marriage is also performed with families. He has not committed any offense. He is in custody. 438. Oh, madam, and he may be enlarged on bail. For contra, the counsel appearing for the state would submit that the petitioner has invoked section 438 of CRPC, and offences against the petitioner is an heinous offence, subjecting the minor girl for sexual act, and also this petitioner married the minor girl, having taken note of the material available on record, particularly the 164 statement of victim girl. She has stated before the learned magistrate that even though she refused, her marriage was performed forcibly, and even when she refused to cohabit with the petitioner, and she was threatened, and without any other reasons, without any other option, she was subjected to sexual act, and having taken note of the material on record, particularly the age of the petitioner, victim is 14 years 8 months, and medical records also discloses that she was subjected to sexual act, and hence there is a prima facie case, and it is not a fit case to exercise the powers under section 438 of CRPC. Next, 89. ಯಾವ್ದು ಹೇಳಿ ಏನ್ ಮೇಡಮ್?
87 minutes.
Wait madam, another 5 minutes.
Let's 87.
ಶ್ರೀನಿವಾಸಯ್ಯ ಹೇಳ್ರಿ ಏನು? 89 ಶ್ರೀನಿವಾಸಯ್ಯ 89 ಇದರ 89 ಅವರು 89 ಇಲ್ಲ ತೋಳಿ. Petitioner counsel absent. List this matter on 21st. Next 90 ನರಸಪ್ಪ.
I'm for the petitioner, my lord. Offense
20B.
under NDPS Act 20B.
ಏನ್ ಕ್ವಾಂಟಮ್ ಏನ್ ಹೇಳಿ?
ಕ್ವಾಂಟಮ್ ಅವ್ರ ಹತ್ರ ರಿಕವರ್ ಮಾಡಿರೋದು 3 kg 750 ಗ್ರಾಮ್ ಗಾಂಜಾ ರಿಕವರ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. From the instances, I'm from A1. From the instance from A1.
3 kg ನಾ?
3 kg 750 ಗ್ರಾಮ್ ಸ್ವಾಮಿ.
ಏನಿ
has a commercial quantity. A2 has commercial quantity. Page number 21 ಇದೆ ಸ್ವಾಮಿ.
ಸಪರೇಟ್ ಮಾಡಿದಾರಾ? ಇವನು ಅಕ್ಯೂಸ್ ನಂಬರ್ ಎಷ್ಟ್ರಿ?
ಇವನು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಇದ್ದಾನೆ ಸ್ವಾಮಿ.
A1
he is A1.
ಕಡೆಯಿಂದ 3 kg ನಾ?
3 kg.
ಅದರ್ ಅಕ್ಯೂಸ್ ಕಡೆಯಿಂದ
350 grams of MDM. Ecstasy tablet. No, 300 tablets. 300 tablets of MDMA. 300 tablets, man. And 60 grams of heroin.
Elli where they were subjected to apprehension?
They were in HSR layout, man. In HSR
layout.
Yes.
Layout ಅಲ್ಲಿ ಎಲ್ರಿ ಹೊರಗಡೆ ಲೇಔಟ್ ಅಂದ್ರೆ ಆಗಲ್ಲ, ಮನೆಗೆ ಏನು
ಬೈಕ್ ಅಲ್ಲಿ ಹೋಗ್ತಾ
ಹೇಳ್ಬೇಕು. ಬೈಕ್
ಅಯ್ಯ
ಬೈಕಲ್ಲಿ ಆಲ್ ಟುಗೆದರ್ ಗೋಯಿಂಗ್ ಅಂಡ್ ಕ್ಯಾರಿಂಗ್ ದಿಸ್, ಹೌದಲ್ವಾ?
ಹೌದು ಸರ್.
ಮತ್ತೆ ಹೆಂಗೆ ಅವನ ಕಡೆಯಿಂದ ಎಷ್ಟು ಇವನ್ ಕಡೆಯಿಂದ ಎಷ್ಟು ಅಂತ ಹೆಂಗೆ ಹೇಳಕ್ಕಾಗುತ್ತೆ?
ಪೇಜ್ ನಂಬರ್ 12 ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನ್ ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಇದೆಯೇನ್ರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ. ಅಯ್ಯೋ ಮೊದ್ಲೇ ಹೇಳ್ಬಿಟ್ರು ಒಳ್ಳೆ ತೋಳು. HCCP 6 time on the ground that records not received. Hence this matter on 21st. 91 Venkatesh R A3 397 criminal antecedents ಇದೆಯಾ? ಅದ್ರಲ್ಲಿ ಫೇಲ್ ಆಗಿದೆ. ಎಷ್ಟು ಕೇಸ್ ಇದೆ ಒಟ್ಟಿಗೆ ಅವನ ಮೇಲೆ? ಎರಡೇನ? ಇದ್ರಲ್ಲೇನು 397 ಅಲ್ಲಿ 3000 ಬೆಲೆ ಬೀಳುವ ನೋಕಿಯಾ ಫೈಲು, ಸುಮಾರು 20,000 ಬೆಲೆ ಬೀಳುವ 2 ಚಿನ್ನದ ಉಂಗುರಗಳನ್ನು ಹಾಗೂ ಹೊಸ ದುಡ್ಡುಗಳನ್ನು, ಗುರುತಿನ ಚೀಟಿ, ಪಾನ್ ಕಾರ್ಡ್ ಎಲ್ಲ. ರಿಂಗ್ ಏನ್ರಿ? ರೆಕಾರ್ಡ್ಸ್ ಇದೆಯಲ್ಲ, ಫಸ್ಟ್ ಹೇಳ್ಬಿಡಿ ಮೊದಲು. ಇದೆಯಾ? ಬಂದಿದ್ಯಾ? ಇವನ್ ಕಡೆಯಿಂದ ರಿಕವರಿ ಇದೆಯಾ? 4 ಕೇಸ್ ಇದೆಯಾ? ರಿಕವರಿ ಇದೆಯಾ? ಇದೇನು 438? ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ 438. ಆಯ್ತು ಇನ್ನೊಂದ್ ದಿವಸ ನೋಡೋಣ ಬಿಡಿ. ಅಲ್ಲ ತೊಗೊಳ್ಳಿ. 91 to 101 ಆಲ್ ಮ್ಯಾಟರ್ಸ್. ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಯಾವ್ದಾರು ಒಂದು ಡೇಟ್. 21st ಡ್ಯೂ ಟು ಪಾಸಿಟಿ ಆಫ್ ಟೈಮ್ ಅರ್ಜೆಂಟ್ ಆಲ್ ಮ್ಯಾಟರ್ಸ್ 21st. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದು ಹೇಳಿ? 92 ಯಾವಾಗ ಬೇಕು? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಂಡಲ್ಲಿ ಕೊಡಿ ಮೇಡಮ್. 18th ಯಾವ್ದು? 92 ಮಾತ್ರ. 18th. ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ 21st. ಬನ್ನಿ, ಪಾಸ್ ಓವರ್ಗೆ ಬನ್ನಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 94 ಹೇಳಿ. ಟ್ಯೂಸ್ಡೇ ಯಾವ ಟ್ಯೂಸ್ಡೇ? ಇಲ್ಲ ಡೇಟ್ ನೋಡಿದಿರ ನೀವು? ದಿನ 100 ಬರ್ತಾ ಇದ್ರಿ, ಅರ್ಧ ದಿವಸ ಕೂತ್ಕೊಳ್ಳೋದು ನೋಡಿ, ಮತ್ತು ಹಂಗೆ ಆಗುತ್ತೆ, ಮತ್ತು ರೀಚ್ ಆಗೋದಿಲ್ಲ. 21st ಬನ್ನಿ ನೋಡೋಣ, ಅಷ್ಟೊತ್ತು ಅವತ್ತಿಗೆ ಕಡಿಮೆ ಆಗ್ತಿರ್ತೀವಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 80 ಮೇಲೆ
18 ವೇಟ್ ಮಾಡಿ ಕೌನ್ಸಿಲ್. ಪಾಸ್ ಓವರ್ ಫಸ್ಟ್ ಇಂದ ಪಾಸ್ ಓವರ್ 41 ನಾಗರಾಜ ಏನಕ್ಕೆ ಮೇಡಮ್ ಅದು 41 ತೊಗೊಳ್ಳಿ ಮೇಡಮ್. This matter is called twice, no representation, and in the earlier occasion also no representation, and it appears that counsel is not pursuing the matter. However, in the ends of justice, one more opportunity is given. Last time we given, and if counsel doesn't appear, avatu ashte 2110 allu illa toli madam, the counsel not appeared before this court from 21/10/2021 and also 2/2/2022, and today also no representation, and this matter called twice, no representation, and hence petition is dismissed for non-prosecution. 42 Praveen. ಇದು ಅಷ್ಟೇನಾ? ಸೇಮ್ ಆರ್ಡರ್ ಮೇಡಮ್. 23/10/21 ಆಮೇಲೆ 2/2/22, and today also matter called twice, no representation, dismissed. 43 ಚಂದ್ರಹಾಸರೈ ಇದು ಅಷ್ಟೇ ಮೋಸ್ಟ್ಲಿ ನೋಡಿ 24/11/21 absent. ಆಮೇಲೆ 2/2/22 also absent. Today also matter called twice. No representation, dismissed. 44 ಶಿವಸ್ವಾಮಿ ಆಮೇಲೆ ಬಂದ್ರಲ್ರಿ ಅವರು ಏನೋ ಟೆಕ್ನಿಕಲ್ ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು ಅಂತ ಹೇಳಿ ಆಯ್ತು. ಆಯ್ತು 21st 45 ಕುಲಕರ್ಣಿ ಇತ್ತೋಳಿ ಕುಲಕರ್ಣಿ ಇದು ಕೂಡ ಅಷ್ಟೇ. ದಿಸ್ ಮ್ಯಾಟರ್ ಕಾಲ್ ಟ್ವೈಸ್, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ಅರ್ಲಿಯರ್ ಆಲ್ಸೋ ದಿಸ್ ಕೋರ್ಟ್ ಮೇಡ್ ಅನ್ ಅಬ್ಸರ್ವೇಷನ್ ದಟ್ ಇಫ್ ಕೌನ್ಸಿಲ್ ಡಸಂಟ್ ಅಪಿಯರ್. ಯಾವ್ರು ಕುಲಕರ್ಣಿ ಅಬ್ದುಲ್ ರಶೀದ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ಮಾಡಿದೀವಿ. ಹೌದಾ ಏನ್ ಮಾಡೋದು ಕೇಸ್ ಅರ್ಧಾಗಿ ನಾನು ಎದ್ದೆ ಹೋಗಿಲ್ಲ, ಹೆಂಗೆ ಎದ್ದು ಹೋಗ್ತಾರ ಅವರು. Sorry, this matter was listed for dismissal. However, comes to know that the petitioner counsel was waiting, but now not present. In the interest of justice, one more opportunity given. This matter on 21st. Chandra Kumare goda baroda illa, dismissed. Third. Last time dismissal ge madidvi. Third madam. Dismissed. Pradeep Kesi. ಏನಕ್ಕೆ ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತೀನಿ ಅಂತ ತಗೊಂಡಿದ್ದೀರಾ? ಹಾಕಿದ್ದೀರಾ? ತಗೊಳ್ಳಿ. ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 21st. 52 ದೇವರಾಜ ಪಿ 22nd ಆಯ್ತು. ಹಿಂದಿನ ಮೇಡಮ್ 22nd ತಗೊಳ್ಳಿ. ದೇವರಾಜ ಪಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ಇವರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ. ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Absent. When this matter listed on 31/1/22, no representation, and on 3/2/2022 also no representation, and today also when this matter called twice no representation, then dismissed. 56. Yes madam, Asha Devi. Yes. Why one ನಿಮಿಷ ಮೇಡಮ್. Monday or Tuesday. He is getting the report regarding antecedents.
I was entitled. I was not very clear what he was waiting. Whether the files are not brought here or what it is.
What he made the submission in the early morning is he instructed to get the antecedents of this petitioner. Morning you are in VC or in here only? Anyhow, now he is getting. He is here in the High Court means?
After the complaints, after the court, the matter was still he is waiting for the IF's.
When the notice was ordered against him, madam? Compliance is your lookout. ಕೊಡಿ ಮೇಡಮ್, ಯಾವತ್ತು ಆಗಿದೆ ಅದು? 3/2 ನಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಯಾವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ? ಫಸ್ಟ್ ಟೈಮ್ ಇವತ್ತೇ ಫಸ್ಟ್ ಟೈಮ್ ಮೇಡಮ್? ಇವತ್ತೇ ಫಸ್ಟ್ ಟೈಮ್ ತಗೊಳ್ಳಿ. HCGP seeks time to get the records and list this matter on 21st. 61 ಮೂಲಿಮನಿ ಏನ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಲ್ರಿ ಬೆಳಗ್ಗೆನು ಇದನ್ನ?
ಹಲೋ
ಏನಾಯ್ತು ಈಗ? 61 ತಗೊಳ್ಳಿ. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 21st. ಗಜೇಂದ್ರ ಕ್ವಾರಂಟೈನ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಬರೀ ಟೈಮ್ ತಗೊಳ್ತಾನೆ ಇದಾರೆ ನೋಡಿ. ತಗೊಳ್ಳಿ, ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. A3 earlier also quarantine. The matter is called twice in the morning and no representation however was made that counsel who is on record is no home quarantine. Last time ಹಿಂದೆ ಮಾಡಿ. This matter periodically listed before this court and no representation earlier. However, on 28/1/2022 a submission was made that the counsel is in home quarantine. But today also no representation, and on 2nd of February also no representation. It appears that petitioner is not pursuing the matter. However, one more opportunity given. If the counsel doesn't appear in the state of hearing, the matter will be dismissed. List this matter on 21st. 63 Ramaswamy.
Yes, petitioner. Petitioner, my lord.
ಯಾರು 6 time? ಬಂದಿದೆಯೇನ್ರಿ? ಆಯ್ತು ತಗೊಳ್ಳಿ. Due to paucity of time, list this matter on 21st. 69 ಸಿದ್ಮಲ್ಲಪ್ಪ, ಅದು ಅಷ್ಟೇ. ಸಿದ್ಮಲ್ಲಪ್ಪ ತೋಳಿ ಏನೋ ವೈಟ್ ಅಷ್ಟು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ರು. ಆಯ್ತು ತೋಳಿ, ಬೆಳಗ್ಗೆ ಯಾರೋ ಟೈಮ್ ಕೇಳಿದ್ರಲ್ಲ, ಪಾಸ್ ಓವರ್ ಅಂತ ಕೇಳಿದ್ರು. ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಡಿಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 21st. 81 ಇಲ್ಲ 81 ಅಲ್ವಾ? ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಂತಿದೆ, ಅದಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತು. ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. ಅದೇ ತಗೊಳ್ಳಿ, ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. 3-2 ನಲ್ಲೂ ಅದೇ ಆರ್ಡರ್ ಆಗಿದೆ. However, in ends of justice, this matter was listed on 3/2/22. No representation. However, this court, in the ends of justice, one more opportunity is given, and today also no representation. And if counsel doesn't appear in the state of hearing, matter will be dismissed on 21st. Gita madam.
Serial number 85, my lord.
100.
Serial number 80, my lord. Serial number 80, my lord.
ಏನಾಗ್ಬೇಕು ಹೇಳ್ರಿ? ಮಂಡೇನಾ? ಮಂಡೇಗೆಲ್ಲ ನೋಡಿದ್ರಲ್ಲ ನೀವು. ಆಯ್ತ್ರಿ, 438 ರೀ. ಮತ್ತೇನು ಹೇಳಕ್ ಇದ್ರ ಜೈಲಲ್ಲಿ ಇದ್ದಂಗೆ ಕೇಳ್ತಿರಲ್ಲ. 438 ಮತ್ತೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 85, my lord.
ನೀವೇ ನೋಡ್ತಾ ಇದ್ರಿ, ಸಿಗೋ ಕುತ್ಕೊಳ್ಳೋದು ಹಾಫ್ ಡೇ ರೀ. 100 ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಆಯ್ತು, 21st ಬನ್ನಿ. ಅಷ್ಟರೊಳಗೂ ಸ್ವಲ್ಪ ಗುಬ್ಬಚ್ಚಿ ಹಂಗೆಲ್ಲ ಇಟ್ಟು ಊಟ ಕೊಟ್ಟು ಎಲ್ಲ ವ್ಯವಸ್ಥೆ ಮಾಡಿ.
Serial number 80, my lord.
8 ಏನಾಗ್ಬೇಕ್ರಿ? 80
I may be permitted to withdraw my petition and with the liberty to file a fresh appeal, my lord.
ಯಾಕೆ ಫ್ರೆಶ್ ಅಪೀಲ್?
Appeal, my lord. Appeal.
ಅದೇನ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ನೋಡ್ರಿ, 17th ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
My lord, serial number 85, my lord. My lord, serial number 85.
ಏನಪ್ಪ ಕೇಳ್ರಿ ತಿಮ್ಮಣ್ಣ? 85 ಏನಪ್ಪ ಕೇಳಿ.
My lord, a short date may be please, my lord.
ಶಾರ್ಟ್ ಡೇಟ್ 21st.
Please.
ಹಾಕೊಂಡ್ರೆ ರೀಚ್ ಆಗೋದಿಲ್ಲ, ಮತ್ತೆ ಅವತ್ತು ಕಾಯ್ಬೇಕಾಗುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ ಕ್ಲಿಯರ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ಬನ್ನಿ ಅವತ್ತು. ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್, ಏನಾಯ್ತು? ಯಾವ್ದ್ರಲ್ಲಿ? ಯಾವ್ದು? ಆಯ್ತು, ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ 21st. ನೀವೇ ನೋಡ್ತಾ ಇದ್ದೀರಲ್ರಿ. ನಾನ್ ಬೆಳಗ್ಗೆ 8:30 ತಿಂಡಿ ತಿಂದವನ್ರಿ. ಬರುವಾಗ ಸಿಟಿ ಬರುವಾಗ ಏನೋ ಒಂಚೂರು 1-2 ವಾಲ್ನಟ್ಟು ಏನೋ ಒಂದು ಹಾಕೋ ಬಂದಿದ್ದೀನಿ ಬಾಯಿಗೆ. ಕೂತ್ಕೊಂಡು ಉಸಿರು ಕಟ್ಕೊಂಡು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀನಿ 2:05 ನಂಗೆ 2:15 ಇಂಟರ್ವ್ಯೂ ಇದೆ. ಈಗ ಊಟ ಮಾಡ್ಬೇಕು, ಓಡೋಗ್ಬೇಕಲ್ಲ ಅಲ್ವಾ? ಮುಗೀತಾ? ಸರಿ ಆಗ್ಬೇಕಲ್ಲ, ಏನ್ ಮಾಡೋದು? ನೀವೇ ನೋಡ್ತಾ ಇದ್ರಿ, ರೀಚ್ ಆಗ್ಬೇಕಲ್ಲ. ಹಾಕೊಂಡ್ರು ರೀಚ್ ಆಗ್ಬೇಕಲ್ರಿ.